opposition to the nomination of Abe Fortas back in 1968, a presidential election year, was simply unheard of. No longer. Democrats blocked cloture 21 times on 10 different circuit court nominees, including outstanding lawyers like Miguel Estrada, whose nomination was filibustered an incredible 7 times. Now, these aren't inflated statistics, Mr. President, like the supposed 78 filibusters Democratic colleagues are now alleging occurred during the Obama administration, which includes numerous instances where the prior Democratic leader unnecessarily filed cloture petitions. No, what I'm talking about are real and repeated filibusters used by Democrats to defeat nominations. In the face of this wholly unprecedented change in the norms and traditions of the Senate, we Republicans contemplating using the nuclear option. We decided against it. 14 colleagues, 3 of whom still serve in this body, reached an accord where filibusters would be overcome for 5 of the 10 nominees in question. Regretfully, Miguel Estrada was not one of them. He had withdrawn his nomination after being put through an unprecedented ordeal. And yet, the ink was barely dry on the accord I mentioned when Senate Democrats, led in part by our friend, the Democratic leader, again did something exceedingly rare in the nominations process. They tried to filibuster Samuel Alito's nomination to the Supreme Court. No member of the Republican conference, by the way, has ever voted to filibuster a Supreme Court nominee, ever. Nobody on this side of the aisle has ever done that. Again, it would have been easy for Republicans to retaliate when President Obama took office. But just like under Clinton, that's not what happened. How did we treat Obama's lower court nominees? Well, at the time, our Democratic colleagues decided to fill up the D.C. Circuit one way or the other, as the Democratic leader put it. Senate Republicans had defeated a grand total of two of President Obama's judicial nominees. So, Mr. President, at the time they decided to employ the nuclear option and fill up the D.C. Circuit, Senate Republicans had confirmed 215 Obama judges and defeated just 2. 215 we had confirmed and defeated just 2. So our Democratic colleagues' decision to employ the nuclear option in 2013 was not in response to rampant obstruction, but was, in the words of the Washington Post, a power play. By the way, at the time, I don't recall the Democratic leader or any other of our Democratic colleagues repeating the refrain, if there aren't 60 votes for a nominee, you don't change the rules, you change the nominee. They weren't saying that then. And what'd they do? They changed the rules. It was a power play, but it was also something else. It was a tacit admission by our Democratic colleagues that the Senate tradition of up or down votes for judicial nominees that they had first upset back in 2003 by starting the practice of filibustering judicial nominees was a tradition they should have respected. Unfortunately, it took them 10 years to realize this, and only after they captured the White House, and only after Republicans also used on a smaller scale the tool they themselves inaugurated a decade earlier. So, Mr. President, how did we treat President Obama's Supreme Court nominees? Did we try to filibuster them, like our Democratic colleagues tried with Justice Alito? Of course not. When President Obama nominated Sonia Sotomayor and Elena Kagan, we treated each nominee fairly, as they would later say themselves, and we secured an up or down vote for both. Most Republicans had significant misgivings about these nominees. Many of us voted no in the confirmation. But we didn't think it would be right to deny them an up or down vote. Ranking Member Jeff Sessions of the Judiciary Committee at the time and I even protested when then Democratic leader Reid tried to file cloture on the Kagan nomination because we were determined to prevent even the hint of a filibuster. Again, we respected the Senate's tradition against filibustering Supreme Court nominees. Now, I know our friends on the Democratic side will be quick to interject with predictable protest about last year, though they seem to forget their own position on the issue. When Justice Scalia passed away, the Senate chose to follow the standard first set forth by then Senator Biden when he was chairman of the Judiciary Committee, and then expanded upon by the current Democratic leader himself. The Senate exercised its constitutional advise and consent role by withholding its consent until after the election, so the next president, regardless of party, could select the nominee. It's a standard I held to, even when it seemed inevitable that our next president was going to be Hillary Clinton. It's also a standard that President Obama's own legal counsel admitted Democrats would have followed themselves had the shoe been on the other foot. The majority of the Senate expressed itself then by withholding consent. The majority of the Senate wishes now to express itself by providing consent to Judge Gorsuch. But the bipartisan majority that supports him can't do so if a partisan minority filibusters. They're prepared to do so for the first time in American history. And the Democratic leader has mused openly about holding this seat vacant for an entire presidential term. We will not allow their latest unprecedented act on judicial nominations to take hold. Mr. President, this will be the first and last partisan filibuster of a Supreme Court nomination. Now, all this history matters. I know the Democratic leader would rather not revisit the circumstances that brought us to this moment. I know the Democratic leader would rather not talk about it. Well, of course he doesn't want to talk about it. He and his party decided to change the ground rules for handling judicial nominations. He and his party pioneered the practice of filibustering lower court judicial nominees. He and his party launched the first partisan filibuster of a Supreme Court nominee. He and his party deployed the nuclear option in 2013. Now they're threatening to do something else that's never been done in the history of the Senate: successfully filibuster a Supreme Court nominee on a purely partisan basis. And for what reason? For what reason? Because he isn't qualified? Because he isn't fit for the job? No. Because he was nominated by a Republican president. This is the latest escalation in the left's never-ending judicial war, the most audacious yet, and it cannot and it will not stand. There cannot be two sets of standards, one for the nominees of Democratic presidents and another for the nominee of Republican presidents. The Democratic leader essentially claimed yesterday that Democratic presidents nominate justices who are near the mainstream, but Republican presidents nominate justices who are far outside the mainstream. In what universe are we talking about here? I would say to my friend from New York, few outside of Manhattan or San Francisco believe that Ruth Bader Ginsburg is in the mainstream, but Neil Gorsuch is not. To quote a longtime Democrat and member of the left-leaning American Constitution Society, there is simply no principal reason, none, to vote no on Judge Gorsuch's nomination. Even less of one to block that vote from occurring at all. So let me say this to my Democratic colleagues. If you truly cannot support the nomination of this eminently qualified nominee, then at least allow the bipartisan majority of the Senate that supports Gorsuch to take an up or down vote. You already deployed the nuclear option in 2013. Don't trigger it again in 2017.
Under the previous order, the leadership time is reserved. Under the previous order, the time until the cloture vote on the Gorsuch nomination will be equally divided between Senators Grassley and Feinstein or their designees.
I was going to ask you, Mr. President,
Senator from Iowa.
I was going to ask you unanimous consent to that extent, so I guess you've already announced that it's in place. Is that right? He just said this.
I'm sorry, sir. It's the
I'm going to add something to what you just said, so let me start over again. I ask unanimous consent that the Senate until 10:45 be equally divided between Senator Feinstein or her designee, or myself or my designee, and the time from 10:45 to 11 be reserved for Senator Schumer's leader's remarks.
Is there objection? Seeing none. It's agreed. Democratic Whip.
Mr. President, my understanding, I'd like to ask for clarification, is that the remaining 17 or 18 minutes is equally divided?
Senator is correct.
That's what my unanimous consent request said.
I just wanted to get more specific, Senator. I'm not questioning what you asked for. So we have 9 minutes each, or 8 minutes each?
No. And I'll probably need more than 9 minutes, but I'll put the rest of my statement in the record.
So will I. So I defer to the chairman of the committee if he'd like to speak first.
Okay. Within the next hour or so, we'll learn whether the minority leader will come to their senses and whether they'll engage in a very first partisan filibuster of a Supreme Court nominee. All indications are that they are committed to their course. That's unfortunate. It truly is. The question you have to ask is this: what exactly is so objectionable about this nominee that he should be subjected to the first partisan filibuster in U.S. history? Is he really not well qualified? Columbia for bachelor's, Harvard for law school, and Oxford for a doctorate. He clerked for not one, but 2 Supreme Court justices over 10 years on the circuit court. He's had 2,700 cases. It's clear then that he is extremely well qualified. So what is it? What makes this nominee so objectionable? The truth of the matter is that throughout this process, the minority, led by their leader, has been desperately searching for a justification for their pre-planned filibuster. Over the course of the last couple of months, they've trotted out one excuse after another, but nothing will stick. They said he isn't mainstream, but that's not true. Everyone from Obama's Solicitor General to Rachel Maddow has said he's mainstream. They said he is an independent, but everyone knows that he is an independent judge. He's his own man, and he understands the role of a judge. And then they rolled out this ridiculous argument that he's for the big guy and against the little guy. Even liberal law professors like Noah Feldman made fun of that attack. He called it, quote unquote, a truly terrible idea. Then they said we should hold him responsible for the legal position that he took on behalf of the United States government. The only problem there is that we've had a lot of nominees who've represented the United States government. They worked for him, and the government was their client. The other side certainly didn't want to hold Justice Kagan responsible for taking the truly extreme position as Solicitor General that the United States government was constitutionally permitted to ban pamphlets. So that argument fell flat as well. Then, of course, after they ran out of substantive arguments against the judge and his record, they resorted to attacks on his supporters, or the president who nominated him, or the selection process. Anything to distract from the judge and this stellar record that he has. They trotted out this absurd claim that we should reject the judge, not because of some opinion he's written, but because those who support his nomination have the gall to actually speak out and make their voices heard. Except they forgot to check with their own supporters, first, to make sure none of them are spending so-called dark money. Of course, they are spending money on issue advocacy, just as the law permits, and the Constitution protects under the First Amendment. And as we all know, issue advocacy during Supreme Court nominations is absolutely nothing new. Those who are complaining about issue advocacy today don't seem to remember the TV ads that the far left ran attacking Judge Bork, 1987. I remember those ads. I remember the ads the left ran against Justice Thomas as well. And of course, outside groups on the left have attacked every Republican nominee since. So expressing selective outrage over issue advocacy doesn't advance their cause either, but they still keep it up. And finally, the talking point we've heard repeated most often over the last 24 hours is that candidate Trump outsourced his selection process to conservative groups. I must say, I find that argument the oddest of all. It's the kind of thing Justice Scalia would call pure applesauce. The president didn't outsource the selection process to conservative groups. He made his list public for the entire country to review during the campaign, the first president to do that. If anything, then he outsourced the selection process to who? The voters, the American people. So what do? You're out of substantive arguments from the other side? Even shots fired at the judge's supporters somehow boomerang and hit your own advocacy groups. But we've seen all of this before. I've been through a few of these debates over the years. When the Republican occupies the Oval Office, the nominees may change, but the attacks remain the same. You'll hear today the same poll-tested catchphrases we've all heard time and again. You'll hear words and phrases like outside of the mainstream, far right, and extreme. Invariably, these are words that the left tries to pin on every nominee of a Republican president and the people he submits to the Senate. With each nominee, the playbook on the left seems to be the very same. The nomination process, it seems, is a desperate attempt to retell the same old preordained narrative. So, as I've said, those of us who have been through a few of these episodes have heard it all before, and we're going to hear it in the next few hours again. But this time, something is very different. This time, they intend to use the same old preordained narrative to justify the first partisan filibuster in the 220-year history of the United States Senate. And of course, this result was preordained because, as a minority leader said weeks before the president was even sworn into office, quote, "It's hard for me to imagine a nominee that Donald Trump would choose that would get Republican support that we Democrats could support," end of quote. You've already committed to the far left that you'll launch the first partisan filibuster in U.S. history. So you're stuck. You've got to press forward, don't you? Even though you know the effort is doomed to fail. You know that he'll be confirmed, and you know in your hearts of heart that he deserves to be confirmed. And that's why this is a especially sad state of affairs. And I hope that my colleagues will change their mind. I yield the floor.
Mr. President,
Minority Whip is recognized.
for 3 straight days, the Senate Republican leader has come to the floor and has given us a history of presidential nominations to the Supreme Court. But clearly, an investigation is necessary. There must have been a hacking into his computer because he can't print the name Merrick Garland to include in the speech. The senator from Kentucky, the Republican leader, has failed to mention that name because that name is the reason we are in this spot today. When Justice Antonin Scalia passed away, President Obama exercised his constitutional responsibility to send a nominee to the Senate to fill the vacancy on the Supreme Court. And for the first time in the history of the Senate, for the first time ever, this Republican-led Senate refused to give this nominee a hearing and a vote. It had never, underline the word never, happened before. Was the reason that he was unqualified? Of course not. He's unanimously well qualified, serving on the D.C. Circuit Court. The reason was stated clearly by Senator McConnell. We're going to place a bet that the next president will be a Republican and let them fill this vacancy. So when the Republicans come to the floor, as they have this morning, talking about the politicization of this process, the reason we are here, when we should be celebrating the 1-year anniversary of Merrick Garland on the Supreme Court, is because they kept that position vacant so it could be filled by a Republican president. That's exactly why we are here today. And this notion that it's somehow fanciful, that the choice of Neil Gorsuch was made by outside groups, is belied by the very words of the president himself, who thanked the Federalist Society and the Heritage Foundation, 2 special interest Republican organizations, for giving him a list of nominees for the Supreme Court. It was very open and public, and there was gratitude, political gratitude, that they came up with the name Neil Gorsuch, and that's a fact. And when you look at the history that's led us to this moment, the senator from Kentucky, the Republican leader, has to accept what is clear. In the history of the United States of America, until Senator McConnell's days under President Obama, exactly 68 nominees had been stopped by filibuster. Under Senator McConnell and the Republicans, 79 nominees of President Obama were stopped. It was an abuse of the filibuster never seen before in the history of our nation. And it was that abuse of the filibuster and statements that they would leave vacancies on critical courts like the D.C. Court of Appeals there forever and ever, amen, that led to the decision 4 years ago to say that we would employ a change in the rules so we could finally fill these court positions, finally break the filibuster death grip, which Senator McConnell had brought to this chamber in a way never before seen in history. So the senator from Kentucky has made history. He comes to the floor every day and tells us history. He made history in the number of filibusters that he used on this floor. He made history in denying a presidential nominee the opportunity for a hearing and a vote, which had never happened before in the history of the United States. Talk about partisanship. And when it comes to this Judge Gorsuch, I read his cases. I sat through the hearings. I was in the Senate Judiciary Committee. We took a measure of the man. He was careful to avoid any question that he could when it came to his position on cases and issues and values. That's not unusual. Supreme Court nominees do that. And so we tried to look at his cases. What do his cases that he decided reveal about the man? And 2 or 3 cases came right to the front. The first involved the sad story of a frozen truck driver on Interstate 88 outside of Chicago in January a few years back. 14 degrees below zero, the brakes on his trailer freeze, he pulls to the side of the road, calls his dispatcher and said, "Stay with the truck, we're sending somebody." Hours pass. He's now going through hypothermia, he's freezing, and he calls the dispatcher and says, "I've got to do something." He said, "You either drag this truck, disabled truck, out on the interstate and take your best chances, or you stick with the truck." He decided to unhitch the trailer, drive to a gas station, gas up, warm up, and come back. For that, he was fired. 7 judges looked at that case to decide whether it was fair to fire Alphonse Madden. 6 of the judges said no, he did the right thing. 1 judge said, "I rule for the trucking company that fired him." Neil Gorsuch, the nominee for the Supreme Court. Hobby Lobby case, the decision was basic. Who should decide the health care of thousands of workers? Well, the Green family that owns Hobby Lobby said our religious beliefs should dominate. We should decide family planning and birth control for our employees and their health insurance. Judge Gorsuch said that's right, because they own a corporation, and a corporation is a person. And as a corporation, they can have sincere religious beliefs. A choice between a corporate ownership of a family and 13,000 employees and their own personal religious rights, Judge Gorsuch rules for the corporation. Kansas State University. Kansas State University professor, after working there for many years, is diagnosed with cancer and has to go through bone marrow transplant, takes 6 months off, and then when she's called back to work, she calls the university and says, "I understand that the influenza epidemic on campus, and I'm afraid, having just had bone marrow transplant, to be exposed to influenza at this point." They said, "You either come back and teach or you're fired." She didn't come back. They fired her. And it was Judge Gorsuch who said their employer was right. Kansas State University was right. Those are insights into the value of a man who wants a lifetime appointment to the United States Supreme Court, the highest court in the land. And the questions we have raised about his judgment and his values go to the heart of who we are and what we want to be. Do we want the Supreme Court to continue to be a voice for the corporations and corporate elite and employers? Do we want to exclude the opportunities of common people like that truck driver, Al Madden, to have his day in court and be treated fairly? That's what it comes down to. It's a fundamental question of fairness and justice. I'm sorry, because I love the Senate, and I've spent a good part of my life here, that we've reached this moment. But this effort to fill the courts of this nation with Republican appointments, even at the expense of violating Senate traditions that are over 100 years old, that has brought us to this moment. As someone said, the nuclear option was used by Senator McConnell when he stopped Merrick Garland. What we're facing today is the fallout. Mr. President, I yield the floor.
Democrat leader.
Mr. President,
The Democratic leader.
this past week, the American people have been exposed to a contentious debate here on the Senate floor about the nomination of Judge Gorsuch to the Supreme Court. The American people have heard many arguments about the judge's merits and his shortcomings. They've also heard senators litigate 4 decades of fierce partisan wrangling over the composition and direction of the federal judiciary. That debate, that long debate, has informed the current one about Judge Gorsuch. Newer members may not remember all the details. Friends of mine, like Senator Hatch, probably remember too many of them. Still, the vote on Judge Gorsuch and the decision by the majority leader to move to change the rules has roped in all of that history. Now, how did we get here? The truth is, over the long history of partisan combat over judicial nominations, there's blame on both sides. We believe that the blame should not be shared equally between Republicans and Democrats. We believe the Republican Party has been far more aggressive in the escalation of tactics and in the selection of extreme judicial candidates, while Democrats have tended to select judges closer to the middle. Keep this in mind. The last time a Republican-controlled Senate confirmed the Supreme Court nomination of a Democratic president was 1895. Nonetheless, each side comes here today in full confidence that their side is in the right. It was once said that, quote, antagonism is never worse than when it involves 2 men, each of whom is convinced that he speaks for the goodness and rectitude. So it is today. My Republican friends feel that they have cause to change the rules because the Democrats changed the rules on the lower court nominees in 2013. We believe we had to change the rules in 2013 because the Republicans ramped up the use of the filibuster to historic proportions, forcing more cloture votes under President Obama than during all other presidents combined. More cloture votes under Obama than under George Washington all the way through George Bush. My Republican friends think they have cause to change the rules because we're about to deny cloture to the nomination of Judge Gorsuch. We believe that what Republicans did to Merrick Garland was worse than a filibuster, declaring mere hours after Justice Scalia's death that they would deny the constitutional prerogative of a president with 11 months left in his term. And as my colleague from Illinois noted, we did not hear 2 words in the long speech of Senator McConnell, Merrick Garland. We could relitigate these debates for the next hour, mentioning everything the Republican leader left out in his remarks. In fact, I'm pretty sure we could argue endlessly about where and with whom this all started. Was it the Bork nomination or the obstruction of judges under President Clinton? Was it when Democrats blocked judges under President Bush or when Republicans blocked them under President Obama? Was it Judge Garland or Judge Gorsuch? Wherever we place the starting point of this long twilight battle over the judiciary, we are now at its end point. These past few weeks, we Democrats have given Judge Gorsuch a fair process, something Merrick Garland was denied. My colleagues came into this debate with an open mind. I think many of them wanted to vote for Judge Gorsuch at the outset. So we met with the nominee. We consented to and participated in his hearing. But over the course of the hearing, during which Judge Gorsuch employed practiced evasions and judicial platitudes, the mood of our caucus shifted. Without so much as a hint about his judicial philosophy, without a substantive explanation of how he views crucial legal questions, all we had to go on was his record. And the more we learned about Judge Gorsuch's record, the more we didn't like. Judge Gorsuch has shown in his rulings and in his writings to side almost instinctively with corporate interests over average Americans. He hasn't shown independence from the president, who so routinely challenges the legitimacy of the judiciary. While he's made a studious effort to portray himself as thoughtful and moderate, his record shows, far from being the kind of mainstream candidate for the Supreme Court that could earn 60 votes, he may very well turn out to be one of the most conservative justices on the bench. An analysis of his record in the New York Times showed he'd be the second most conservative judge on the bench, and one in the Washington Post showed he'd be the most conservative justice, even to the right of Justice Thomas. For these principled reasons, Judge Gorsuch was unable to earn enough Democratic support for confirmation. Because of that, the majority is about to change the standing rules of the Senate to allow all Supreme Court nominees to pass on a majority vote. It doesn't have to be this way. When a nominee doesn't get enough votes for confirmation, the answer is not to change the rules. It's to change the nominee. Presidents of both parties have done so in similar situations. On several occasions, Supreme Court nominees were withdrawn because they did not have enough support. One was even withdrawn after a failed cloture vote. So this week, we have endeavored to give the majority leader and my friends on the other side of the aisle a way out of this predicament. We offered them the option to sit down with Democrats, with we Democrats and the president, and discuss a nominee who would earn enough bipartisan support to pass the Senate, not one vetted only by far-right special interest groups. I came here to the floor each day and made an offer to meet anywhere, anytime, to discuss a new nominee. I hoped, perhaps naively, that we could discuss a way forward that both our parties could live with. Unfortunately, there were no counter-offers or discussion offered by the other side. But our offer was meant sincerely. Democrats and Republicans are caught in such a bunker mentality on this issue that we're just talking past each other. I know that many of my Republican friends are squeamish and uncomfortable with the path we are on, as we Democrats are as well. We've reached a point where the level of distrust is so high on this issue we can't even sit down and talk. My Republican friends dismiss as out of hand the notion that Democrats will ever vote to confirm a Republican-nominated judge, despite the fact that there were Democratic votes for both Justices Roberts and Alito to get them over 60, and despite our plangent attempts to convince them otherwise. But make no mistake about it. For all the back and forth, when history weighs what happened, the responsibility for changing the rules will fall on the Republicans and Leader McConnell's shoulders. They have had other choices. They have chosen this one. No one forced them to act. They acted with free will. We offered them alternatives. They refused. They hardly entertained any other possibilities. It seemed that the Republican leader was, from day one, intent on changing the rules if he didn't get his way. And frankly, this is how so many of our Republican friends have approached the judiciary for a long time. For 2 decades, they have done whatever it has taken to move the bench to an ideological far-right position. Independent experts have stated that we have a more conservative Supreme Court than we've had in a very long time. Nothing, not even the rules, not even the comity of the Senate, seems to stop them. When the dust settles, make no mistake about it, it will have been the Republicans who changed the rules on the Supreme Court. But we take no solace that history will put it on their shoulders, because the consequences for the Senate and for the future of the Supreme Court will be far-reaching. The nuclear option means the end of a long history of consensus on Supreme Court nominations. It weakens the standing of the Senate as a whole, as a check on the president's ability to shape the judiciary. In a post-nuclear world, if the Senate and the presidency are in the hands of the same party, there's no incentive to even speak to the Senate minority. That's a recipe for more conflict and bad blood between the parties, not less. The cooling saucer of the Senate will get considerably hotter. The 60-vote threshold on controversial matters is a hallmark of the Senate. The majority leader has said so himself. It fosters compromise. It fosters bipartisanship. It makes the Senate more deliberative. 60 votes ought to be the epigraph of the Senate. Losing that standard on the Supreme Court, a hugely controversial matter, erodes the very nature of this body. Mr. President, the 60-vote bar in the Senate is the guardrail of our democracy. When our body politics is veering too far to the right or to the left, the answer is not to dismantle the guardrails and go over the cliff, but to turn the wheel back toward the middle. The answer is not to undo the guardrails, the rules. It's to steer back to the middle and get a more mainstream candidate. With respect to the Supreme Court, the 60-vote threshold operates as a guardrail against judicial extremism. When 60 votes, typically a bipartisan supermajority, are required for confirmation, nominees tend to be in the judicial mainstream. The only nominee on the court to be confirmed with less than 60 votes was Justice Thomas, who is widely recognized to be the most ideological extreme Supreme Court justice. It'll mean the end of any pressure on any future president to nominate someone in the mainstream. When it comes to the courts, the guardrails are being dismantled. There will be more 5-4 decisions, as our ranking member of the Judiciary Committee has pointed out. There will be less faith in the Supreme Court because it will be seen as a political body, an extension of our most divisive debates. And as a result, America's faith in the integrity of the court and the trust in the rule of law will suffer. In conclusion, Mr. President, I am disheartened that we are here. In the sweep of history, the Senate has been the place where great, seemingly intractable disagreements in American politics finally give way to compromise, precisely because we have a set of rules that requires it. The story of the Senate is one of fierce debate, but eventual cooperation. We tend to pull back when things get too heated, because we all care about this institution and its role in our national life. In this case, cumulative resentments from years of partisan trench warfare were too great. Instead of the Senate forcing us to change, senators have decided to change the Senate. And I worry a great deal about what that means for our future. 20 years ago, I think even the most partisan would say that the 60-vote threshold was basically inviolable. Today, it will be gone for all nominations, but at least not for legislation. Now, my friend, the Majority Leader, has said he has no interest in removing the barrier for legislation. I agree with him wholeheartedly, and I take him at his word. I hope that we can get together to do more in future months to ensure that the 60-vote threshold for legislation remains. But just as it seemed unthinkable only a few decades ago that we changed the rules for nominees, today's vote is a cautionary tale about how unbridled partisan escalation can ultimately overwhelm our basic inclination to work together and frustrate our efforts to pull back, blocking us from steering the ship of the Senate away from the rocks. There's a reason it was dubbed the nuclear option. It's the most extreme measure with the most extreme consequences. And while I'm sure we will continue to debate what got us here, I know that in 20 or 30 or 40 years, we will sadly point to today as a turning point in the history of the Senate and the Supreme Court. A day when we irrevocably moved further away from the principles our founders intended for these institutions. Principles of bipartisanship, moderation, and consensus. Let us go no further on this path. I yield the floor.
The clerk will report the motion to invoke cloture.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, do hereby move to bring to a close debate on the nomination of Neil M. Gorsuch of Colorado to be an Associate Justice of the Supreme Court of the United States, signed by 17 senators.
By unanimous consent, the mandatory quorum call has been waived. The question is it the sense of the Senate that debate on the nomination of Neil M. Gorsuch of Colorado to be an Associate Justice of the Supreme Court of the United States shall be brought to a close? The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Mr. Cochran. Ms. Collins. Mr. Coons. Mr. Corker. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Crapo. Mr. Cruz. Mr. Daines. Mr. Donnelly. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Mrs. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Flake. Mr. Franken. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hatch. Mr. Heinrich. Ms. Heitkamp. Mr. Heller. Ms. Hirono. Mr. Hoven. Mr. Inhofe. Mr. Isaacson. Mr. Johnson. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mr. Manchin. Mr. Markey. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Markowski, Mr. Murphy, Mrs. Murray, Mr. Nelson, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mrs. Shaheen, Mr. Shelby, Ms. Stabenow, Mr. Strange, Mr. Sullivan,
Aye.
Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young. Senators voting in the affirmative: Alexander, Barrasso, Collins, Cornyn, Crapo, Cruz, Flake, Grassley, Hatch, Isaacson, Kennedy, Manchin, McConnell, Perdue, Roberts, Rounds, Scott, Strange, Sullivan, Tillis, Wicker. Senators voting in the negative: Baldwin, Blumenthal, Cantwell, Carper, Casey, Coons, Cortez Masto, Duckworth, Durbin, Feinstein, Franken, Harris, Hassan, Hirono, Klobuchar, Leahy, McCaskill, Menendez, Merkley, Murphy, Murray, Peters, Sanders, Schatz, Schumer, Stabenow, Warren. Mr. Cardin, no. Mrs. Shaheen, no. Mr. Young. Aye. Mr. Young, aye. Mr. Warner. Mr. Warner, no. Mr. Markey, no. Mr. Paul, aye. Mr. Wyden, no. Mr. Udall. Mr. Udall, no. Mr. Cassidy. Mr. Cassidy, aye. Mr. Toomey. Mr. Toomey, aye. Mrs. Fisher. Mrs. Fisher, aye. Mr. Nelson. Mr. Nelson, no. Mr. Booker. Mr. Booker, no. Mrs. Ernst. Mrs. Ernst, aye. Mr. Reed. Mr. Reed, no. Mr. Donnelly. Mr. Donnelly, aye. Mr. Sass. Mr. Sass, aye. Mr. Tester. Mr. Tester, no. Mr. Daines. Mr. Daines, aye. Mr. Corker. Mr. Corker, aye. Mr. Van Hollen. Mr. Van Hollen, no. Mr. King. Mr. King, no. Mr. Heinrich. Mr. Heinrich, no. Mr. Whitehouse. Mr. Whitehouse, no. Mr. Lee. Mr. Lee, aye. Mrs. Capito. Mrs. Capito, aye. Mr. Risch. Mr. Risch, aye. Mr. Moran. Mr. Moran, aye. Mr. Hoven. Mr. Hoven, aye. Mr. Shelby. Mr. Shelby, aye. Mr. Rubio. Mr. Rubio, aye. Mr. Gardner. Mr. Gardner, aye. Mr. Bozeman. Mr. Bozeman, aye. Ms. Markowski. Ms. Markowski, aye. Mr. Cochran. Mr. Cochran, aye. Mr. Heller. Mr. Heller, aye. Mr. Graham. Mr. Graham, aye. Mr. Enzi. Mr. Enzi, aye. Mr. Inhofe. Mr. Inhofe. Aye. Ms. Heitkamp. Ms. Heitkamp. Aye. Mr. Langford. Mr. Langford. Aye. Mr. Kane. Mr. Kane. No. Mr. Cotton. Mr. Cotton. Aye. Mr. Bennett. Mr. Bennett. Aye. Mr. Brown. Mr. Brown. No. Mrs. Gillibrand. Mrs. Gillibrand. No. Mr. Thune. Mr. Thune. Aye. Mr. Blunt. Mr. Blunt. Aye. Mr. Burr. Mr. Burr. Aye. Mr. McCain. Mr. McCain. Aye. Mr. Portman. Mr. Portman. Aye. Mr. Johnson. Mr. Johnson. Aye. Mr. McConnell. Mr. McConnell. No.
Any senator wishing to change their vote? If not, on this vote, the yeas are 55, the nays are 45. 3/5 of the senators duly chosen and sworn not having voted in the affirmative, the motion is not agreed to. Majority Leader.
I move to reconsider the vote and ask for the ayes and nays.
Is there a sufficient second? There is. Clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Mr. Cochran. Ms. Collins. Mr. Coons. Mr. Corker. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Crapo. Mr. Cruz. Mr. Daines. Mr. Donnelly. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Mrs. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Flake. Mr. Franken. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hatch. Mr. Heinrich. Ms. Heitkamp. Mr. Heller. Ms. Hirono. Mr. Hoven. Mr. Inhofe. Mr. Isaacson. Mr. Johnson. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mr. Manchin. Mr. Markey. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Nelson. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott. Mrs. Shaheen. Mr. Shelby. Ms. Stabenow. Mr. Strange. Mr. Sullivan.
Aye.
Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young. Senators voting in the affirmative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cochran, Collins, Cornyn, Cotton, Daines, Donnelly, Enzi, Ernst, Fisher, Flake, Gardner, Graham, Grassley, Hatch, Heitkamp, Heller, Inhofe, Isaacson, Johnson, Kennedy, Lankford, Manchin, McCain, McConnell, Moran, Murkowski, Perdue, Portman, Risch, Roberts, Rounds, Rubio, Sass, Scott, Shelby, Strange, Sullivan, Thune, Tillis, and Toomey. Senators voting in the negative: Baldwin, Bennett, Blumenthal, Booker, Brown, Cantwell, Cardin, Casey, Cortez Masto, Duckworth, Durbin, Feinstein, Gillibrand, Harris, Hassan, Heinrich, Hirono, Kane, King, Klobuchar, Leahy, Markey, McCaskill, Menendez, Merkley, Murray, Nelson, Peters, Reed, Sanders, Schatz, Schumer, Shaheen, Stabenow, Tester, Udall, Van Hollen, Warner, Warren, Whitehouse, and Wyden. Mr. Hoeven, aye. Mr. Young, aye. Aye. Mr. Lee, aye. Mr. Crapo, aye. Mr. Paul, aye. Mr. Cruz, aye. Mr. Coons, no. Oops. Mr. Corker, aye. Mr. Cassidy, aye. Mr. Carper,
I recorded.
The senator is not recorded.
Carper votes no.
Mr. Carper, no. Mr. Wicker, aye. Mr. Franken, no. Mr. Murphy, no.
Are there any senators in the chamber wishing to change his or her vote? If not, the yeas are 55, the nays are 45. The motion to reconsider is agreed to.
Madam President,
The Democratic leader.
may we have order?
Order in the chamber.
Madam President, parliamentary inquiry.
The Democratic leader will state the parliamentary inquiry.
Is it correct that over half the nominations on which cloture motions were filed in the Senate over the course of our entire history as a country were filed between the beginning of President Obama's administration and November 21st, 2013?
The Secretary of the Senate's office confirms that 79 of the 147 cloture motions filed on nominations were filed between 2009 and November 1st, 2013.
Madam President, further parliamentary inquiry.
The Democratic leader will state the parliamentary inquiry.
Under the rules and precedents of the Senate, is the Senate prohibited from considering and voting on a nominee to the Supreme Court in the 4th year of the President's term?
The chair is not aware of any such prohibition in its rules or precedents.
Madam President, additional parliamentary inquiry.
The Democratic leader will state the parliamentary inquiry.
Is the chair aware of any instance in the years between the 1949 advent of routine public Supreme Court confirmation hearings and 2016 that a nominee who was not withdrawn did not receive a hearing and a vote?
The Secretary of the Senate's office confirms that since 1949, Supreme Court nominees have routinely received public hearings. Harriet Miers, whose nomination was withdrawn, and Merrick Garland did not.
Madam President, in order to allow President Trump, Republicans and Democrats time to come together and discuss a way forward on a Supreme Court nominee that can meet the 60-vote threshold, I move to postpone the nomination to 3 p.m. on Monday, April 24th, and I ask for the yeas and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Mr. Cochran. Ms. Collins. Mr. Coons. Mr. Corker. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Crapo. Mr. Cruz. Mr. Daines. Mr. Donnelly. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Mrs. Ernst. Mrs. Feinstein. Mrs. Fisher.
No.
Mr. Flake. Mr. Franken. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hatch. Mr. Heinrich. Ms. Heitkamp. Mr. Heller. Ms. Hirono. Mr. Hoven. Mr. Inhofe. Mr. Isaacson. Mr. Johnson. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mr. Manchin. Mr. Markey. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Nelson. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mrs. Shaheen, Mr. Shelby, Ms. Stabenow, Mr. Strange, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young, Mr. Moran, Mr. Cochran. Mr. Sass. Mr. Cornyn. Mr. Carver. Senators voting in the affirmative: Baldwin, Blumenthal, Booker, Brown, Cantwell, Cardin, Carper, Casey, Cortez Masto, Donnelly, Duckworth, Durbin, Feinstein, Franken, Gillibrand, Harris, Hassan, Heinrich, Heitkamp, Hirono, Kane, King, Klobuchar, Manchin, Markey, McCaskill, Menendez, Merkley, Murphy, Murray, Nelson, Reed, Sanders, Schatz, Schumer, Shaheen, Stabenow, Tester, Udall, Van Hollen, Warren, Whitehouse, Wyden. Mr. Bennett, aye. Senators voting in the negative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cassidy, Cochran, Collins, Cornyn, Cotton, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Flake, Gardner, Graham, Grassley, Hatch, Heller, Hoven, Inhofe, Isaacson, Johnson, Kennedy, Langford, Lee, McConnell, Moran, Murkowski, Paul, Perdue, Portman, Rounds, Rubio, Sass, Scott, Shelby, Strange, Sullivan, Thune, Tillis, Toomey, Wicker, Young. Mr. McCain. Mr. McCain, no. Mr. Roberts. Mr. Roberts, no. Mr. Peters. Mr. Peters, aye. Mr. Corker. Mr. Corker, no. Mr. Risch? Mr. Risch? No. Mr. Coons? Mr. Coons? Aye. Mr. Leahy? Mr. Leahy? Aye. Mr. Warner? Mr. Warner? Aye.
Are there any senators wishing to change their vote? On this motion, the yeas are 48, the nays are 52. The motion is not agreed to.
Madam President,
The Majority Leader.
our Democratic colleagues have done something today that is unprecedented in the history of the Senate. Unfortunately, it has brought us to this point. We need to restore the norms and traditions of the Senate and get past this unprecedented partisan filibuster. Therefore, I raise a point of order that the vote on cloture under the precedent set on November 21st, 2013 is a majority vote on all nominations.
The precedent of November 21st, 2013 did not apply to nominations to the Supreme Court. Those nominations are considered under the plain language Rule 22. The point of order is not sustained.
I appeal the ruling of the chair.
Madam President,
The Democratic Leader.
parliamentary inquiry.
The Democratic Leader will state the parliamentary inquiry.
Did the Senate precedent established on November 21st, 2013 on how nominations are considered in the Senate change the cloture threshold for nominations to the Supreme Court?
Consideration of nominees to the Supreme Court of the United States was unaffected by the precedent of November 21st, 2013, and is as under Rule 22.
Madam President, a second parliamentary inquiry.
The Democratic Leader will state the parliamentary inquiry.
In the history of the Senate, have there been any instances where a nomination to the Supreme Court was withdrawn after cloture was not invoked on the nomination?
The Secretary of the Senate's office has confirmed that such a withdrawal has taken place.
Thank you, Madam President. And Madam President, parliamentary inquiry.
The Democratic Leader will state the parliamentary inquiry.
Of the last 26 nominations of justices confirmed to the Supreme Court going back to 1954, how many were confirmed without a roll call vote or received more than 60 votes in support of their nomination, either on cloture or on confirmation?
The Secretary of the Senate's office confirms that 25 of 26 nominees were confirmed in one or another of the manners so described.
Madam President, I move to adjourn until 5 p.m. I ask for the yeas and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Brown. Mr. Burr. Ms. Cantwell. No. Mrs. Capito. Mr. Cardin. Mr. Carper. Gotcha. Yep. Yep. Gotcha. Sir. Mr. Casey. Mr. Cassidy. Mr. Cochran. Ms. Collins. Mr. Coons. Mr. Corker. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Crapo. Mr. Cruz. Mr. Daines. Mr. Donnelly. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Mrs. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Flake. Mr. Franken. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hatch. Mr. Heinrich. Ms. Heitkamp. Mr. Heller. Ms. Hirono. Sir. Mr. Hoven. Mr. Inhofe. Mr. Isaacson. Mr. Johnson. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Leahy. Mr. Lee. Mr. Manchin. Mr. Markey. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Nelson. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Rounds. Mr. Rubio. Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mrs. Shaheen, Mr. Shelby, Mr. Strange, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young, Senators voting in the affirmative: Baldwin, Bennett, Blumenthal, Booker, Cantwell, Cardin, Carper, Casey, Cortez Masto, Donnelly, Duckworth, Durbin, Feinstein, Franken, Gillibrand, Harris, Hassan, Heinrich, Heitkamp, Hirono, Kane, Klobuchar, Leahy, Manchin, Markey, McCaskill, Menendez, Merkley, Murphy, Murray, Nelson, Peters, Reed, Sanders, Schumer, Shaheen, Stabenow, Udall, Van Hollen, Warner, Warren, Whitehouse, and Wyden. Senators voting in the negative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cassidy, Cochran, Collins, Corker, Cornyn, Cotton, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Flake, Gardner, Graham, Grassley, Hatch, Heller, Hoeven, Inhofe, Isaacson, Johnson, Kennedy, Lankford, Lee, McCain, McConnell, Moran, Murkowski, Paul, Perdue, Portman, Roberts, Rounds, Rubio, Sass, Scott, Shelby, Strange, Sullivan, Thune, Tillis, Toomey, and Wicker. Mr. Risch? No. Mr. Coons? Aye. Mr. King, aye. Mr. Schatz, aye. Mr. Brown, aye. Mr. Tester, aye. Mr. Young, no. Are there any senators in the chamber wishing to change his or her vote?
You want me to bring it then?
Yes, sir.
Are there any senators in the chamber who wishes to change their vote, who wish to change their vote?
If not,
If not, the yeas are 48, the nays are 52.
the motion to adjourn is not.
The motion to adjourn is not agreed to. The question is, shall the decision of the chair stand as the judgment of the Senate?
I ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Brown. Mr. Burr, Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Cardin, Mr. Casey, Mr. Cassidy, Mr. Cochran, Ms. Collins, Mr. Coons, Mr. Corker, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Crapo, Mr. Cruz, Mr. Daines, Mr. Donnelly, Ms. Duckworth, Mr. Durbin, Mr. Enzi, Mrs. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Blake, Mr. Franken, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hatch, Mr. Heinrich, Ms. Heitkamp, Mr. Heller, Ms. Hirono, Mr. Hoven, Mr. Inhofe, Mr. Isaacson, Mr. Johnson, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mr. Manchin, Mr. Markey, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Nelson, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mrs. Shaheen, Mr. Shelby, Ms. Stabenow, Mr. Strange, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young, Senators voting in the affirmative: Baldwin, Blumenthal, Booker, Brown, Cantwell, Carper, Casey, Coons, Cortez Masto, Donnelly, Duckworth, Durbin, Feinstein, Franken, Gillibrand, Harris, Hassan, Heinrich, Heitkamp, Hirono, Kane, Klobuchar, Leahy, Manchin, Markey, Menendez, Merkley, Murphy, Murray, Nelson, Peters, Sanders, Schumer, Shaheen, Stabenow, Tester, Van Hollen, Warren, Whitehouse, Wyden. Mr. Udall, aye. Senators voting in the negative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cassidy, Cochran, Collins, Corker, Cornyn, Cotton, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Flake, Gardner, Graham, Grassley, Hatch, Heller, Hoven, Inhofe, Isaacson, Johnson, Kennedy, Lankford, Lee, McCain, McConnell, Moran, Murkowski, Hall, Perdue, Risch, Roberts, Rounds, Sass, Scott, Shelby, Strange, Sullivan, Tillis, Toomey, Wicker, Young. Mr. Schatz. Mr. Schatz, aye. Mr. Cardin. Mr. Cardin, aye. Mr. King. Mr. King, aye. Mr. Bennett. Mr. Bennett, aye. Mr. Reed. Mr. Reed, aye. Mr. Rubio. Mr. Rubio, no. Mr. Thune. Mr. Thune, no. Mrs. McCaskill. Mrs. McCaskill, aye. Mr. Warner. Mr. Warner, aye. Mr. Portman. Mr. Portman, no.
The ayes are 48, the nays are 52. The decision of the chair does not stand as the judgment of the Senate. We need to do that again. Let's have order. On this vote, the ayes are 48. The nays are 52. The decision of the chair does not stand as the judgment of the Senate. The clerk will report the motion to invoke cloture.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, do hereby move to bring to a close debate on the nomination of Neil M. Gorsuch of Colorado to be an Associate Justice of the Supreme Court of the United States, signed by 17 senators.
By unanimous consent, the mandatory quorum call has been waived. The question is it the sense of the Senate that debate on the nomination of Neil M. Gorsuch of Colorado to be an Associate Justice of the Supreme Court of the United States shall be brought to a close upon reconsideration? The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mr. Blumenthal. Mr. Blunt. Sir. Mr. Booker. Mr. Bozeman. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Mr. Cochran. Ms. Collins. Mr. Coons. Mr. Corker. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Crapo. Mr. Cruz. Mr. Daines. Sure. Mr. Donnelly. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Mrs. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Flake. Mr. Franken. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hatch. Mr. Heinrich. Ms. Heitkamp. Mr. Heller. Ms. Hirono. Mr. Hoven. Mr. Inhofe. Mr. Isaacson. Mr. Johnson. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Leahy. Mr. Lee. Mr. Manchin. Mr. Markey. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Nelson. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mrs. Shaheen, Mr. Shelby, Ms. Stabenow, Mr. Strange, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young, Senators voting in the affirmative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cassidy, Cochran, Collins, Crapo, Cruz, Daines, Donnelly, Enzi, Fisher, Gardner, Graham, Grassley, Hatch, Heitkamp, Hoeven, Inhofe, Isaacson, Johnson, Kennedy, Langford, Lee, Manchin, McConnell, Moran, Murkowski, Paul, Perdue, Portman, Roberts, Rounds, Sass, Shelby, Strange, Sullivan, Thune, Tillis, Toomey, Wicker, and Young. Mr. Markey. Mr. Cotton, aye. Senators voting in the negative: Baldwin, Bennett, Blumenthal, Brown, Cantwell, Carper, Casey, Cortez Masto, Duckworth, Durbin, Feinstein, Franken, Gillibrand, Harris, Hassan, Heinrich, Kane, King, Klobuchar, Leahy, Markey, Murray, Nelson, Peters, Reed, Sanders, Schumer, Shaheen, Stabenow, Tester, Udall, Van Hollen, Warner, Warren, Whitehouse, and Wyden. Mr. Corker, aye. Mr. Coons, no. Mr. Cornyn, aye. Mr. Cardin, no. Mr. Murphy, no. Mr. Flake, aye. Mr. Booker, no. Mrs. Ernst? Aye. Mrs. McCaskill? No. Mr. Risch? Aye. Mr. Schatz? No. Mr. McCain? Aye. Mr. Scott? Aye. Mr. Rubio? Aye. Ms. Hirono? No. Mr. Merkley? No. Mr. Menendez? No. Mr. Heller? Aye. Are there any senators in the chamber wishing to change his or her vote?
Are there any senators in the chamber wishing to change his or her vote? Seeing none, the final vote is 55 yeas, 45 nays. Upon reconsideration, the cloture motion is agreed to.
You to take your place, Orrin?
Madam President.
The Majority Whip.
Madam President, may we have order?
The Senate will be in order. The Majority Whip.
Madam President, the Senate has just restored itself to an almost unbroken tradition of never filibustering judges. We have actually restored the status quo before the administration of President George W. Bush. It was during that administration when some of our friends across the aisle, along with some of their liberal law professor allies, dreamed up a way of blocking President George W. Bush's judicial nominees. And that was by suggesting that 60 votes was really the threshold for confirming judges rather than the constitutional requirement of a majority vote. It's been a long journey back to the normal functioning of the United States Senate. And it's amazing that it's taken a nominee like Judge Gorsuch to bring us back to where we were back around 2001. We've been debating and discussing this nominee for a long time now, and they've tried, or the opponents of Judge Gorsuch have tried time and time again to raise objections to this outstanding nominee, a nomination that no one in the Senate opposed 10 years ago when he was confirmed to a position on the 10th Circuit Court of Appeals. They've claimed he wasn't mainstream enough. They've said this was a seat that really should have gone to Merrick Garland. They've even accused him of plagiarism. All of these arguments have no merit whatsoever and really represent desperate attempts to try to block this outstanding nominee. Their claims were simply baseless. And that much became even clearer as folks from across the political spectrum and newspapers from across the country urged our Democratic colleagues to drop their pointless filibuster and allow an up or down vote. What also came to light is the type of man Judge Gorsuch is, a man of integrity, a man of strong independence. In other words, exactly the kind of person you would want to serve on the United States Supreme Court. They even claimed that Judge Gorsuch went out of his way to side with the big guy against the little guy, ignoring the fact that during his 10 years on the 10th Circuit Court of Appeals, where these judges sit in multi-judge panels, that he was part of the majority decision 99% of the time. 97% of those cases were unanimous in multi-judge panel decisions on the 10th Circuit Court of Appeals. Hardly a radical. It actually is a remarkable record of a consensus builder, someone who uses his great intellect his education, and his training to build consensus on a multi-judge court, exactly the kinds of skills that are going to be so important for him to use on the Supreme Court of the United States. So as I said, ultimately today was a culmination of years of obstruction by our Democratic colleagues when it came to judicial nominees. When I came to the Senate in 2003, the Democrat strategy was well underway to obstruct lower court judicial nominees from the George W. Bush administration. And later, in 2013, when there was a Democrat in the White House and it suited them to do so, they decided to do away with the same tool they used and went nuclear, lowering the threshold from 60 to 51 majority vote for circuit court nominees and district court nominees. It took a gang of 14, 7 Democrats and 7 Republicans, to try to work through the differences back around 2006 timeframe, which resulted in half of President George W. Bush's nominees to the circuit courts getting confirmed and half not being confirmed. And the standard was adopted by this so-called Gang of 14 that only under extraordinary circumstances would the filibuster be used. But that agreement expired in 2013. Well, the minority leader and his colleagues like to say that back then it was necessary to restore a majority vote. He did that on just last Sunday. He said our Republican colleagues had been holding back on just about all of so many lower court judges, including the very important D.C. Circuit Court, that they were forced to engage in the nuclear option back in 2013. But the facts really belie what the Democratic leader claimed in terms of the necessity of going nuclear back then. In fact, prior to 2013, the Senate had confirmed more than 200 of President Obama's judicial nominees, and it rejected just 2. More than 200 confirmed, 2 rejected. That hardly rises to the level of extreme obstruction or partisanship. That's a 99% confirmation rate for President Obama. So let's make it clear just how this began. It started with Democratic obstruction under a Republican administration in 2001, and it's been continuing now under a new Republican administration in 2017. So we really have come full circle to restore the status quo before 2001, when our Democratic friends started down this path. President Trump has, by all accounts, selected a judge with impeccable qualifications and the highest integrity. Not one of our Democratic colleagues has been able to offer a convincing argument against him, and that's why several of our Democratic colleagues have crossed the aisle to support his nomination, and I thank them for that. I think more would join if they didn't fear retribution from the radical elements in their own political party. So today, Republicans in the chamber are following through on what we said we would do. We said we would let the American people decide who would select the next Supreme Court nominee, and then we would vote to confirm that nominee. The American people on November the 8th selected President Trump. President Trump nominated Judge Neil Gorsuch, and tomorrow we will confirm that nominee and deliver on that promise. Mr. President, I yield the floor.
Mr. President.
Senator from Colorado.
Thank you, Mr. President. Over the next several hours, we'll have the final opportunity to debate the confirmation of Supreme Court Justice nominee Neil Gorsuch. This has been a lengthy process this week, as we've heard from senators on both sides of the aisle come to the floor and talk about their support or their opposition to Judge Gorsuch's nomination to the Supreme Court. I've had several opportunities over the past weeks, months, to personally visit and speak with Judge Gorsuch, whom I've known from Colorado. The opportunity to listen to a number of my colleagues address the chamber, to watch the Senate confirmation hearings and the Judiciary Committee, the day after day it seemed that confirmation hearing proceeded, and of course have gotten to know Judge Gorsuch over the past several years. We're proud that we have a Coloradan nominated to the nation's highest court, that he would be the second Coloradan to serve on the Supreme Court. The other one being, of course, Justice Byron White. Justice Byron White also led the NFL in rushing one year. And while Judge Gorsuch will never live up to that part of the Supreme Court legacy for Coloradans, we know that Judge Gorsuch is an avid outdoorsman, a fly fisher, expert-level skier, somebody who understands public lands. And I think having that kind of expertise and experience on our nation's highest court will serve this country well. I think it's important to understand that his roots represent the roots that built the West. He's a fourth-generation Coloradan, somebody who hails from a state that's independent, that takes great pride in its libertarian streak, its outdoor love of the outdoors, recreational opportunities, understanding agriculture, energy. It's a state that really does have it all, and from the eastern plains to the western slope, the great beauty of our state. Neil Gorsuch understands that. He served on a court, the 10th Circuit Court, that is housed in Denver, that represents 20% of the land mass of our state. Judge Gorsuch's family, as I mentioned, really does show the grit and determination of those who built the West. His grandfather, somebody who worked in Union Station, somebody who grew up driving trolleys back in the time when Denver was a trolley town. His other grandfather, of course, was a physician, both of whom had experts in their field, medicine. One grandfather helped found a law firm, Gorsuch Curtis, very prestigious firm in Denver. But it's Judge Gorsuch's experience, his high qualifications of academics that he brings to the court, having received degrees from Columbia, Oxford, Harvard. As I mentioned previously, the most important academic experience being the University of Colorado, where I think he spent at least some time in the summer attending and also teaching, of course, at a professor at my alma mater, the University of Colorado School of Law, has all helped him build what he is today, and that is a very mainstream jurist, an incredibly exceptional legal mind, one of the brightest jurists this country has to offer, somebody who's known as a feeder judge, providing clerks to the Supreme Court, and who has the respect of the Colorado legal community. Now, I want to talk about some of these things because I've come to the floor multiple times, and I have talked about his qualifications. I have talked about the fact that the people who know him best aren't the people in Washington, D.C., but the people who have practiced in front of his court in Denver, the people who know him personally out in Colorado. And here's what those individuals have said. They believe that Judge Gorsuch deserves an up or down vote. Bill Ritter, former Democratic governor of the state of Colorado, believes that Judge Gorsuch deserves an up or down vote. Now we will have it. We've invoked cloture. We'll have a final debate on Friday night and a final vote on whether or not he should be confirmed. People like Steve Farber, the co-chair of the Democratic National Convention in 2008 in Colorado, have talked about the need to confirm Judge Gorsuch. And so the debate that we enter now is not one of whether or not he'll have an up or down vote. He's going to have an up or down vote. But it's whether or not we should confirm him, actually give him the yes vote. And I urge my colleagues on both sides of the aisle to vote in favor of Judge Gorsuch's confirmation. And just some of the arguments that I have heard over the past several weeks on the floor, listening to some of the arguments on the floor, it's quite interesting to me that some of the arguments we hear seem to be at odds with each other. Presiding over the Senate yesterday, I heard people talk about how they don't think that Neil Gorsuch will stand up to the president. They're concerned that he won't express the kind of independence that the judiciary commands, that he won't be somebody to stand up to the President of the United States. They often cite some of the comments or tweets that the president has made and then fail to mention the fact, though, that at the very time that one of those tweets was mentioned questioning the judiciary, that Judge Gorsuch, in a meeting with one of our Democratic colleagues, actually said objections. He said he objected to the statements the president had made, expressing his independence, talking about how it was demoralizing what he had heard, showing very much independence. But the second argument that you often hear for those who have decided to oppose this mainstream jurist is that they're afraid he won't show enough deference to the president, and then they say they're concerned about his language as it relates to the Chevron deference, the Chevron doctrine, whether or not Judge Gorsuch is going to be willing to overturn the Chevron doctrine. Now, I find these two arguments kind of interesting because on one hand, you have an argument saying we're afraid he's not going to stand up to the President of the United States. And then on the other hand, you have an argument saying that we're afraid he's going to stand up to the administrative state of the President of the United States. Because that's what the Chevron doctrine does. It gives great deference to the regulatory body, to the administrative state. Now, here's another irony. The administrator of the EPA in 1984 was Neil Gorsuch's mother, Ann Burford. The administrator of the EPA, the first woman to serve as EPA administrator, who was the subject of the Chevron doctrine. Not only is he willing to stand up to the president and the administrative state of the president, but he's willing to overturn a case that was a subject that his own mother was a subject to. I've also heard comments from colleagues on the aisle that Judge Gorsuch is not a mainstream jurist. Now, this argument, I think, can be dealt with in a couple of ways because there's some pretty good statistics to refute these arguments. 97%. 97% is the number of times in the 2,700 opinions that he was a part of. 97% represents the time that was a unanimous decision. Judge Gorsuch didn't serve only with conservative appointed judges. He didn't serve with only Republican nominees. Judge Gorsuch served with Republican and Democrat nominees, appointments approved by the Senate. And in 97% of the cases, Judge Gorsuch decided in unanimous decisions. Now, the other statistic that I think is even more revealing, of course, of whether or not Judge Gorsuch is a mainstream judge is 99%. 99% is the amount of time that Judge Gorsuch ruled with the majority of the court. Made decisions, opinions, with the majority of the court. Now, I heard a comment yesterday from a colleague who said that Judge Gorsuch was never intended to be a mainstream nominee. Now, if Judge Gorsuch was never intended to be a mainstream nominee, do you think we would see a judge before us that has support from the 2008 Democratic National Convention chairman? If Judge Gorsuch was never intended to be a mainstream nominee, do you think we'd have the decisions by the Democratic governor of Colorado, former Democratic governor of Colorado, to demand or ask for an up or down vote? If Judge Gorsuch was never intended to be a mainstream nominee, do you think the president would have nominated somebody who agreed 99% of the time with his colleagues on the bench? Colleagues who came from appointments given by Republican presidents and Democrat presidents. The arguments over whether or not Judge Gorsuch is going to be with the little guy or he spends too much time defending the big guy. Well, let me just, again, go back to the people who know Judge Gorsuch the best, who've served and who've practiced in front of his court. Now, here's a statement from a Denver attorney and Democrat on representing underdogs before Judge Gorsuch. This was in the Denver Post. Statement, he issued a decision that most certainly focused on the little guy. But yet the story from the opposition here out of 2,700 cases is, oh my gosh, this is a person who's never defended the little guy. Well, here's somebody who's practiced in front of them and practiced in front of his court who absolutely believes he focused on the little guy. So we have a judge who agrees with the majority of the court most of the time, 99% of the time. 97% of the time it's a unanimous decision. Who lawyers practicing in front of him believe that he represents the little guy. We've heard from leading Democrat voices in Colorado who support him. The ABA's highest qualifications, rankings, ratings, believe it. But then the question becomes, what are we looking for in a justice? And maybe that's the biggest argument here. Maybe the argument should be about what are we looking for in terms of philosophy, ideology? Well, we've seen his ideology and his philosophy in what he has testified before the judiciary, what he's testified, what he's stated and passed through writings, that he is somebody who is going to follow the law. He is somebody who is going to take a decision where the law leads him, not somebody who is going to take an opinion or decision where his personal beliefs or politics take him. That's the kind of judge that we want on the highest court. That's the kind of justice that we want. Somebody who's not going to decide a policy preference from the bench of the Supreme Court, not somebody who's going to take a look at a public opinion poll or somebody who's going to take a look at a focus group and make a decision, but somebody who will rule by the law. I've heard colleagues come to the floor and talk about their experiences where they were given decisions to read without given the law and decided whether or not, just the facts, they were given just the facts of a case. And they said, how would you have decided this case? And then they show them the actual ruling, the actual holding in the case. And some people believe, well, that's not the way we would have decided because we don't feel that that was a good outcome, that we don't feel that that was the right policy. It's not the job of a justice to put their thumb on the scale of policy. It's the job of a justice to be a guardian of the Constitution, to defend the Constitution, to follow the law, and to decide cases based on the law, not on feeling, preference, politics, polls, public. We have a justice who has said, we have a judge nominated for justice, who has said that a judge who believes, who agrees with every opinion that they've issued is probably a bad judge. He's paraphrasing other judges and justices throughout our history. It's because he knows that it's not his job to issue opinions or decisions or to decide a case based on being a Republican or a Democrat. It's not his job to decide a case based on whether he was nominated by President Trump or President Obama or President Bush. It's his job to look at the law, to leave policy decisions to the legislative branch. That's what we have to do. That's what Judge Gorsuch has said he will do. And so these arguments, they just don't hold water. They don't hold water that he's not looking out for the interests of our citizens, because here clearly he is. Democrats who've practiced before him in court have said as much. The argument that he won't stand up to the Trump administration, we know it. He said it in front of our Democratic colleagues, that he would stand up to the president. He's said that he rejected attacks on the court. And we also know that when it comes to the Chevron doctrine, which seems to be sacred ground now, that there's this ironic argument taking place. Because you want somebody who will stand up to the administration, but then you're concerned that he's interested or concerned that we've taken the Chevron deference, the doctrine of Chevron deference, too far. Now, which is it? Do you want a judge who's going to stand up to the administration, or do you want a judge who's not going to stand up to the administration? Because it sounds like the arguments are trying to have it both ways. But at the bottom line, we know Judge Gorsuch to be a person who is eminently qualified, a mainstream jurist who has the respect and admiration of judges around the country, who has the admiration and respect of fellow jurists and legal professionals throughout Colorado. And we know that he will make this country proud, and he's certainly going to make Colorado proud as he receives his confirmation to the nation's highest court. And I hope as we spend these hours debating that we can realize this Senate should operate in a bipartisan fashion, that we should confirm judges who are clearly mainstream. Mr. President, I yield the floor.
Senator from Colorado.
I have 7 requests for committees to meet during today's session of the Senate. They have the approval of the majority and minority leaders.
Without objection. Duly noted.
Yield the floor.
Mr. President.
Senator from Delaware.
Mr. President, today is a day when many senators are speaking about Judge Gorsuch and about the Supreme Court. And as I think many know, in the last week in the Judiciary Committee hearings and in other settings, I have announced I will vote against Judge Gorsuch on the final vote tomorrow, and I believe I have made my reasons for my opposition clear. I have thoroughly reviewed and considered Judge Gorsuch's record and where he fits within American jurisprudence, and I have no second thoughts about my decision. But as I look around at what has just happened on this Senate floor, I am sick with regret. So I rise now to speak in defense of the Senate. The Senate has been hailed by many, including our nominee to the Supreme Court, Judge Gorsuch, as the world's greatest deliberative body. And yet today, I think one more blow has been struck at that title and reality. The late Senator Robert Byrd, who served in this chamber for 51 years, would famously remind new senators that in war and in peace, the Senate has been the sure refuge and protector of the rights of the states and of a political minority. Of course, although Senator Byrd was the longest-serving senator as a Delawarean, I grew up in the tradition of Senator Joe Biden, a 36-year veteran of this body, who left its ranks only to ascend to the vice presidency and spend 8 more years as its presiding officer. Since I had the honor of assuming Senator Biden's former seat, I have committed to following his example of working across the aisle through Republican and Democratic administrations with whomever is willing to roll up their sleeves and get to work for the American people. And I know my colleagues share in this foundational commitment to serve our constituents and country. But as I look around at what just happened on this floor, with too little discussion of its lasting consequences and too little visible concern or even emotion, I must ask the question, where are we headed? You can't see it, but around this chamber are white marble statues, busts of former presiding officers, of former vice presidents of the United States. They are in the halls outside this chamber. They are at the upper level of this chamber in the galleries, and all the former vice presidents are memorialized in these white marble busts. And former Vice President Adlai Stevenson, the grandfather of the Illinois governor who ran for president in the middle of the 20th century, former Vice President Adlai Stevenson said when he delivered his farewell address to the Senate on his last day in office as the presiding officer of the Senate in 1897, said, and I quote, "It must not be forgotten that the rules governing this body are founded deep in human experience. They are the result of centuries of tireless effort to conserve, to render stable and secure the rights and liberties which have been achieved through conflict. By its rules, the Senate wisely fixes the limits to its own power. Of those who clamor against the Senate and its mode of procedure, it may truly be said they know not what they do. In this chamber alone are preserved without restraint 2 essentials of wise legislation and good government, the right of amendment and of debate." Close quote. It was exactly that right, those rules, that were assaulted today, but have been under assault for a long time. In recent days, I have reached out to my Republican and Democratic colleagues, trying to see if there was some way we could reach a reliable consensus agreement to safeguard these institutional values and avoid the events of today and tomorrow. I told my colleagues I was not ready to end debate on Judge Gorsuch's nomination until we could chart a course for the Senate to move forward on a bipartisan basis when considering future Supreme Court nominations. I think for us to get to any constructive conversation about moving this Senate forward requires owning the role that all of us, each of us, have played over our time here, whether a few years or decades, in bringing us to this point. I, for one, will say I have come over time to regret joining my Democratic colleagues in changing the rules for lower court nominations and confirmations in 2013. Of course, I could give an entire speech on the obstruction that led us to that point. I could document the Republican and Democratic deeds and misdeeds of the last Congress and the Congress before that and the decade before that. As my more seasoned and seniored colleagues demonstrated in the Judiciary Committee deliberations, those who have served here longest know best the record of grievance of Congresses and decades past. And I anticipate that many of my colleagues will come to regret the decisions and actions taken today and tomorrow in this Congress and in Congresses ahead. And instead of focusing on that shared regret, I want to work together not to continue to tear down the traditions and rules of the Senate, but to find ways to strengthen and fortify and sustain them. I worked to try and find a solution to get past this moment on the brink. I wanted to ensure our next Supreme Court nominee would be the product of bipartisan consultation and consensus, as was safeguarded for years by the potential of a 60-vote margin. I wanted certainty that the voice of the minority would still be heard when the next vacancies arise. Among many, this effort to forge consensus was met with hopelessness or even hostility. And back home, thousands of constituents called my office urging a vote against Gorsuch and urging I support the filibuster, and some even urged me to stop talking about any sort of deal. In fact, back home in Delaware, some national groups ran ads against me when there was even a rumor of a hint that there might be conversations about avoiding this outcome. There were senators on both sides of the aisle who told me that an agreement was impossible. They said any agreement is based on trust, and we simply do not trust each other anymore. Given the events of the last years, the disrespect and mistreatment of Merrick Garland, the course of the confirmation of Neil Gorsuch, I can understand how there is a raw wound right now in this chamber, where each side feels the other has mistreated a good and honorable and capable nominee for the Supreme Court. But let me say my last point again. Senators of both sides told me we could not find a durable compromise because we do not trust each other anymore. If we cannot trust each other anymore, then are there any big problems facing this country which we can address and solve? This morning I gave an address at the Brookings Institution about the threat that Russia poses to our democracy, to our allies, to our national security, and to the endurance of our republic. If that threat is not something that deserves determined bipartisan effort, I don't know what is. There are many threats to our future I could lay out today, but let me simply emphasize that in the absence of trust, this body cannot play its intended constitutional role. And without trust, we will not rebuild what is necessary to sustain this body. Now, everyone likes to point the finger at the other side as the source of this distrust. The reality is there is abundant blame to go around. Folks like to remember the good old days when Justice Scalia was confirmed by this body 98-0, when Justice Ginsburg was confirmed 96-3. But if we look at our 5 most recent nominees to the Supreme Court that got votes, you can see a clear trend. 9 senators, all Republicans, voted against Justice Breyer. Then 22 senators voted against Justice Roberts. Then 42 senators, mostly Democrats, voted against Justice Alito. For President Obama's nominees, Justices Sotomayor and Kagan, more than 30 Republican senators opposed each one. Only 9 Republican senators voted for Sotomayor, and only 5 Republicans voted for Justice Kagan. We have been on this trajectory, both parties, for some time. Then, of course, we have Chief Judge Merrick Garland, the first Supreme Court nominee in American history to be denied a hearing and a vote. And we have Judge Gorsuch, the first to be the object of a partisan filibuster on this floor. We did not get here overnight. We have become increasingly polarized. How can we work together to repair this lack of trust so we can face the very real challenges that face our nation? My own attempts of recent days, although I was blessed to be joined by senators of goodwill and good faith and great skill in both parties, were ultimately not successful. I wish I had engaged sooner and more forcefully. I wish I had been clearer with my colleagues how determined I was to seek a result. But this doesn't mean I'm disappointed that I tried. And it also doesn't mean I'm going to stop. I am not going to stop trying to fix the damage that has been done, trying to find a better pathway forward. And I ask my colleagues, if you know what you have done today, then what will we do tomorrow? How can we avoid the further deepening, corrosive partisanship in this body? What past mistakes can each of us own up to? What steps can we take to mend these old wounds? And what more can we do to move forward together? We sometimes talk about the dysfunction of this body as if it is external to us, as if we bear no accountability for it. But at the end of the day, here we are, 100 men and women sent to represent 50 states of this republic and 325 million people. And in many ways, we have all let them down today. I can tell you, Mr. President, what I am going to do tomorrow. I commit to working with anyone who wants to join me to try and strengthen and save the rules and traditions of this body and its effectiveness as an absolutely essential part of the constitutional order for which so many have fought and died. It is what all of our predecessors would have wanted. Thank you, Mr. President. With that, I yield the floor.
Mr. President.
The senator from Georgia.
Mr. President, I'm going to be brief, and I also want to make sure I don't take advantage of the personal privilege I have as a United States Senator, but I'm going to anyway. I want Senator Coons from Delaware to pause for just a second. I want to thank every member of the Senate, Republican and Democrat, and the staff of the Senate for the many kindnesses they've extended to me in the last 4 months during my injury and my recovery. I'm on the way back home in large measure because of the support of the members of the United States Senate. I'm very grateful to that and the staff that have allowed that to take place. I say thank you very much. Notwithstanding what your politics are or what your partisanship is or anything else, this is a great institution and a great body because it's made up of great people. To that end, my friend Senator Coons from Delaware made an excellent speech, which I'm going to adopt as my speech since I don't have the strength to stand as long as I'd like to talk about an issue so important. But we do need to open all our minds and our hearts in the days ahead to make sure we know what direction we're going on as members of the United States Senate, regardless of our party and notwithstanding our partisanship. Neil Gorsuch, from everything I have seen, I've probably seen more than anybody because I've been watching it on TV while I've been recovering, so you guys have had to do it in debate. I've seen the real thing. His record, his testimony, the way he presented himself, the way Senator Grassley and Senator Feinstein allowed that hearing to go forth. I know we had a good man as a nominee for the Supreme Court Justice of the United States. But the issues in the divide on cloture, on simple majority, on the rule change of 2013, and what's happened in the past, and now it has us in a position where we're slowly but surely moving to be a body that's another House of Representatives, not a United States Senate. The majority rule is a great philosophy. Majority winning is always a great philosophy. But I used to have a teacher that taught me and said, if 4 equals a majority, 3 equals 0, but she said, you always need to listen to the other 3 because sometimes they may be right. I think that's a good lesson for us today, and that was a grammar school teacher. 4 does equal, if 7 of the voting members, 4 does equal a majority, but 3 doesn't equal 0 because the rest still count. As we move forward in the days ahead and we judge other issues, whether they be partisan issues in terms of regular debate and general legislation, whether they be issues over confirmation of judges or secretaries or whatever it may be, let's be thoughtful so that not as a criticism of the House, but as a compliment to our founding fathers, we don't become a second House and later a unicameral body of majority rule and mob rule and eventually wave rule, where passions overrule common sense and all of a sudden you find yourself digging your way out of holes that you created rather than building buildings and dreams you always wanted to do. So I commend the leadership of both parties for exercising their political and partisan desires. I commend each member for being here to take part of this debate today and be a part of it. That's what America's all about. But somewhere down the line, there's going to be something that's going to happen. It's going to cause a resurrection of the debate that we've had today and another road to cross on which way we would go in future direction. The more we move away from a Senate that is a deliberative body, that is a dignified body, and that is a body that makes sure it knows where it's going before it moves forward, we'll be better off. If we move towards a body that's a rubber stamp of the House or a unicameral government of legislation, we'll never be the United States of America our founding fathers intended us to be. That's what I believe, and that's what I think the end of this will be. So to all our members, I compliment them on everything they've had to say and do. To Justice Gorsuch, I'm so proud to have someone like that who will serve on the bench of the United States Supreme Court with distinction. But to all of us, our job's not finished. Our job's ahead of it. I look forward to being here and being a part of it. I yield back my time and thank the members of the United States Senate.
Mr. President. Senator from Oregon.
For a brief question.
Senator from Rhode Island.
Mr. President, I thank the Senator for Oregon for yielding to me. I just wanted to say how nice it is to see the Senator from Georgia back here with us, and it means a lot to all of us to have Senator Isaacson back home in the Senate.
Mr. President, I don't want to turn this into a bouquet tossing contest, but I think it is very clear that senators on both sides of the aisle are very, very pleased to see our friend from Georgia back today. We are wishing him good health and Godspeed, Johnny, and look forward to a full and complete recovery, and so glad to have you here. I'm also pleased that Senator Coons is on the floor, because I think it would be fair to say that members on both sides of the aisle who have watched how Senator Coons has conducted himself throughout this extraordinarily contentious debate would say that Senator Coons makes all of us very, very proud. It's no secret that he has tried repeatedly to bring both sides together, and he and I have talked often about this. I think there are going to be opportunities for finding common ground on some important legislation, breaking out of this gridlock that we all understand is not what the Senate is all about, and towards more mainstream politics. And when we get there, to a great extent, it will be because of the thoughtful comments of my friend from Delaware, and I appreciate it. Mr. President, the Senate is soon going to act on one of its most sacred and important constitutional duties, the advice and consent on the nomination of the next Associate Justice of the Supreme Court. The long tails of these Supreme Court debates stretch through generations and shape our government deep into the future. The choice the Senate makes in this extraordinary debate will have a profound impact from the broadest governing statutes down to the most specific particulars of the law that affect our daily lives. There are several issues, Mr. President, particularly relevant to this nominee that have gotten short shrift. I'm talking about secret law, warrantless wiretapping, death with dignity, and I intend to discuss these issues shortly. I would like to begin, however, by stating that whether one supports or opposes Judge Gorsuch, our job would have been easier had the judge been more forthcoming in his testimony before the Judiciary Committee. He chose, however, not to do so. So what the Senate has to go by instead is the judge's lengthy record of adhering to a rigid and far-right philosophy that is packaged in the branding of so-called originalism. The originalist says that our rights as a people are contained within and linked to our founding documents. But that viewpoint is plainly incorrect. And in practice, this originalism becomes a cover for protecting the fortunate over the poor, corporations over individuals, and the powerful over virtually every other American. It is a political agenda that masquerades as philosophy, an agenda whose sole intent is reserving power for those in power and limiting the recognition of the rights reserved to the people. Far from endorsing such a creed, our Constitution is actually a document of constraints, constraints that bind the government, not the people. The full scope of our fundamental rights as a people, as Justice Harlan once wrote, and I quote, cannot be found in or limited by the precise terms of the specific guarantees elsewhere provided in the Constitution. The exact concept is written into the Bill of Rights. The 9th Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. James Madison, the founder, so significant that Americans are said to live in a Madisonian democracy, was outspoken about the dangers of future readers or interpreters thinking that the fundamental rights contemplated by the framers were limited to the Constitution or a Bill of Rights. So our founding document and its framers made clear that rights were not enumerated by the Constitution, they were retained by the people. Individual liberties, from personal privacy, a woman's right to vote, the choice of contraception and abortion, interracial marriage, same-sex marriage, equal protection of the law. These liberties, and let me emphasize, many, many, many more have always existed. In fact, the Constitution and the Bill of Rights were silent on much of what Americans consider fundamental to a free people. That silence left the door open for the courts as we shed the prejudices of a darker age to recognize the true meaning of the words, all men are created equal and inalienable rights. But the progress has been painfully slow. The Constitution, like any document composed by politicians, is fraught with original sin. For example, the 3/5 compromise was a shameful device of political accommodation. And through long stretches of our history, political agendas have left many individual rights unrecognized or unprotected by the courts. They ruled in favor of the powerful and against the disadvantaged and the disenfranchised, often with the justification that their rulings adhered to the text of the Constitution. Nowhere did the Constitution expressly deny women the right to vote, but the Supreme Court ruled against Virginia Minor in 1875. The federal government was not expressly granted a right to intern residents of Japanese descent, but the Supreme Court allowed it in Korematsu. There was no constitutional basis on which to deny people of different ethnicities the right to marry. On those issues and more, our judges were wrong. Supreme Court justices were wrong. In the service of the economic, political, and religious powers that be, the court has defended slaveholders, denied the franchise, permitted racial, sexual, and other discrimination, and routinely, Mr. President, elevated the power of the state over individual liberties. And any defense of those rulings as adhering to the text of the Constitution is just plain wrong. Let's look more closely at women's voting rights. In Minor versus Happerstedt, the Supreme Court found that women did not have the right to vote because the right was not expressly stated anywhere in the Constitution. In a unanimous decision, the court took the absurd position that a document predicated on voting, organized by voting, and dependent on voting for any amendment, still did not protect the right to vote for all citizens. Such is the intellectual bankruptcy of a long legal tradition sustained by its defense of the status quo. The 19th Amendment was a response to the abridgment of a fundamental right by political parties and their dependent courts, but it did not create a new right. It was a long overdue fix made necessary by an originalist court. If there is a national evolution that extends protections of rights and liberties to disenfranchised and oppressed people, it is because with time, our wonderful country tends to correct its wrongs. It did so with the Civil War and the amendments that followed. It did so with women's suffrage and the Brown decision, and it did so more recently with the Obergefell versus Hodges decision. Historically, our country has gradually recognized fundamental rights and liberties. Recognition. I use that word intentionally. It is recognition because there are no new rights per se. They are inalienable, and those rights are not limited to those spelled out in the Constitution. A jurist governed by that principle would respect individual rights, but that simply isn't the viewpoint taken by many so-called originalists on the far right today. Their right-wing originalism looks, in my view, a lot more like the judicial philosophy that trampled on the rights of Americans in days past. A philosophy that throughout our history has left many Americans marginalized, disenfranchised, and oppressed by the state. And unfortunately, after listening very carefully to Judge Gorsuch present his views, reviewing his writings, including some I'll mention that specifically talk about my home state, I have no faith that Judge Gorsuch would be any different from this philosophy that I mentioned that has left so many Americans marginalized in our country. Judge Gorsuch not only has a long record of conservative activism in the courtroom, he has demonstrated an out-and-out hostility toward the right of individuals to make decisions about their own lives and their own families without interference from the state. In one troubling instance, he went so far as to author a book attacking death with dignity. This, of course, has been a matter that's historically been left to the states, and the people of my state twice approved death with dignity ballot measures, and our death with dignity law has been in place for nearly 20 years. The Supreme Court upheld it more than a decade ago in a case known as Gonzales versus Oregon. But Judge Gorsuch's record and his own words puts the will of millions of Oregonians in question. Nothing in the Constitution gives the federal government the power to deny suffering Oregonians the right to make basic choices about the end of their lives. There is nothing in the Constitution that gives the federal government the power to deny people in my state the right to make those emotional, difficult, wrenching decisions about end of life. It is a private matter between individuals and doctors. And when politicians attempt to force regulations through the back door by going after doctors and their ability to prescribe, in my view, that is an obvious, over-the-line federal infringement. But my guess is there are probably going to be some folks on the far right that are going to try that route again. Nothing Judge Gorsuch said in his confirmation hearing gave me any indication he respects the death with dignity issue as settled law, or that he would rule against federal abuse of power to intrude on a private choice. The bottom line is that Judge Gorsuch is locked into an extreme right-wing viewpoint on this issue, and there is more. And part of this, Mr. President, is as I've listened to this debate, and particularly the number of comments that some of those who have espoused the views that concern me so much come back to, is they're always talking about states' rights. States' rights. That will be the altar that we really build our views and philosophies around. Well, I'll tell you, when you listen to some of what they're having to say about states' rights, what they're really saying is they're for the state if they think the state is right. And that is not, in my view, what fundamental rights, particularly ones that have been afforded the states, ought to be all about. So as I indicated, I think his views with respect to death with dignity really do involve federal abuse of power intruding on private choices, but there are other issues that concern me as well. He has made it clear in many instances he favors corporations at the expense of working people. He sided with insurance companies to deny disability benefits to people with disabilities, large companies to deny employees basic job protections. And he's even written that class action lawsuits are just tools for plaintiffs to get free rides to fast riches. No example better illustrates the tendency, my colleagues have talked about it, than the case of the truck driver in Trans Am Trucking versus Department of Labor. And in a case that just leaves you practically speechless, Judge Gorsuch sided against a truck driver who was fired for leaving his freezing cold truck when his life was in danger. I had another significant concern about Judge Gorsuch that came up in the context of his confirmation hearings, and this is something that I think a lot of Americans and even those in government are, I think, trying to get their arms around. I've been on the Intelligence Committee since the days before 9/11, and one of the things that we've come to feel strongly about is the danger of what I call secret law. And I want to make sure people know exactly what I'm talking about when I describe secret law. In the intelligence world and in the national security sphere, operations and methods, the tactics used by our courageous men and women who are protecting us, who go in harm's way to protect our people, those sources and methods have always got to be secret. They're classified, and they have to be, because if they got out, we could have Americans die. The people who do all that wonderful work, and possibly millions more. So sources and methods have got to be secret. But the law and our public policies always ought to be transparent. The American people need to know about them, because that is how we make informed decisions in our wonderful system of government. Voters are given enough information to make the choices. And so, sources and methods, operations, secret, but the law and political philosophies has got to be public. And Judge Gorsuch, as a senior attorney in the Department of Justice, was a practitioner of secret law. And as I indicated, the public isn't going to know about secret operations. We protect it, but trust in government and in our legal system can't survive when Americans understand a law says one thing and then the government or a secret court says it means another. Secret law prevents the public from knowing whether their fundamental rights are being infringed by an unaccountable, unconstrained government aided by compliant courts. And secret law also keeps the Congress in the dark. Congress, whose job it is to represent people and oversee the government. Congress, who, barring rebellion, is the only recourse of a free people against an executive judicial alliance of secrecy that infringes their liberties. And it's my view that secret law makes a mockery of the oath that members of Congress, justices, and each senator here have taken to preserve, protect, and defend our Constitution. Secret law is fundamentally corrosive to the rule of law in America. And as we learned during his confirmation hearings, Judge Gorsuch was a supporter of secret law. In 2005, the CIA was conducting a secret torture program. In May of that year, the Department of Justice's Office of Legal Counsel determined secretly that torture techniques such as waterboarding were legal. Somehow it deemed them consistent with statutory prohibitions on torture in the Constitution. This was extraordinary, willful, faulty legal analysis. It was entirely inconsistent with how the Congress and the public would read the law or the Constitution. So then, our distinguished colleague from Arizona, Senator McCain, who knows a little bit about these issues, having been subjected to them in the defense of our country, Senator McCain got passed the Detainee Treatment Act. And Senator McCain understood, having fought for our country, given fully of himself, that our government had to find a way out of this problem. And the McCain law prohibits the cruel and inhuman or degrading treatment that has been at issue here. By any measure, both the law, the language of the law, the clear intent of the Congress, and the context in which it was passed would leave every American to understand that a decision had been made by their elected officials to limit the power of government. But Judge Gorsuch, then an employee of the Bush administration, had a solution. In December of 2005, he wrote to the author of the Justice Department opinion, Mr. Bradbury, about a presidential signing statement that would magically transform the McCain law into an endorsement of torture. What Judge Gorsuch wrote was that the McCain amendment that prohibited cruel, inhuman, and degrading treatment was best read as essentially codifying existing interrogations policies. In other words, according to Judge Gorsuch, John McCain's law, the one that passed 90-9 in the United States Senate, that somehow John McCain's law endorsed torture when it did just the opposite. The issue came up in his nomination hearing. Judge Gorsuch's explanation was he was making the recommendation as a lawyer helping his client, which was the administration. I got to say, Mr. President, there's one thing we've learned. This just following orders defense has gone on for far too long in this city. It is a small and feeble excuse, unbecoming of a judge nominated to the highest court in the land. A judge justifying government violations in the law and the Constitution just so his boss can say, I was following the advice of counsel. That is making a choice to do wrong. The McCain Amendment, what we passed here in the Congress, did not green light torture. It did not codify torture, period. And anybody who's ever heard John McCain talk about this issue, describe his personal horrifying experiences with torture, knows that it certainly could not have been his intent in writing the bill. And any lawyer, especially one secretly advising the government, first has an obligation to the law and the Constitution. Judge Gorsuch's failure to recognize that principle and his choice to do wrong, in my view, disqualifies him from a seat on the United States Supreme Court. Torture is not the only illegal program on which Judge Gorsuch left his fingerprints. After news broke of the illegal warrantless wiretapping program, Judge Gorsuch helped prepare testimony for the Attorney General, which asserted that these authorities are vested in the President and they're inherent in the office. It added, and I quote, "They cannot be diminished or legislated away by other co-equal branches of the government." If that were the case, then no action taken in this area by the elected representatives of the people has any weight. The Foreign Intelligence Surveillance Act that existed since the 1970s would be just some kind of advisory statement. Section 702 of the Foreign Intelligence Surveillance Act, which we're going to debate this year, be little more than wasted paper. And the USA Freedom Act, which ended the bulk collection of law-abiding Americans' phone records, might as well never have been signed into law. Voting for those bills, voting to confirm Judge Gorsuch, call into question any member's commitment to those laws that we passed. In response to a question during his nomination hearing, Judge Gorsuch said that he didn't believe the Attorney General's testimony and that, again, he was only acting as a scribe, as a speechwriter, and as such, he absolved himself of responsibilities for his actions. Again, I think that it's just wrong to use this as an excuse. Like the endorsement of torture, assertions of presidential authority to override congressional limits on warrantless surveillance rip at the fabric of the rule of law. Judge Gorsuch, a man who chose to get up and go to work every day for individuals who are violating the law, Judge Gorsuch had the power to say no, and he would not make that choice. Colleagues, the Senate is voting to confirm an individual to a lifetime position on the Supreme Court. What Judge Gorsuch has stood for and against over the course of his legal career, as we all go into this debate, we'll have to reflect on. A history of support, in my view, for secret, illegal, and unconstitutional programs is an unacceptable record for someone seeking a place on the Supreme Court. I'm reminded the Senate again and again in this talk how the Supreme Court has rubber-stamped the executives of has rubber-stamped the excesses of our executive and legislature over the years rather than to defend our liberty. That's the record. The Supreme Court rubber-stamping the excesses of the executive and legislature rather than protecting the individual liberties of the American people. My view is it's our job as senators to ensure that the Supreme Court does not repeat the errors of yesterday, enshrining disenfranchisement and discrimination and denying equal protection of the law based on prejudice and political agendas. And I believe the only way to prevent this abuse is to appoint judges who recognize that the judiciary is a bulwark against any attempt to infringe on our inalienable rights. So the bottom line for me, colleagues, is whether Judge Gorsuch recognizes that rights are reserved to the people. There is no respect for individual rights and liberty to be found in a viewpoint that allows for secret law to justify torture, that favors the powerful over the powerless, or that tramples on the rights of Americans to determine the courses of their own lives. Unfortunately, we have learned over the last few weeks, this is Judge Gorsuch's record. I oppose his nomination. I urge my colleagues to do the same, and I yield the floor.
Mr. President.
Senator from Montana.
Mr. President, one of the most consequential votes that I'll ever cast is a vote to confirm a United States Supreme Court nominee. It's a lifetime appointment to our nation's highest court. And in fact, tomorrow when I cast that vote for Judge Gorsuch, it'll be the first chance I've had as a senator to confirm a Supreme Court nominee. As it stands today, the United States Senate is on the precipice of confirming Neil Gorsuch to be our next United States Supreme Court Associate Justice. Just a few short hours ago, my colleagues on the other side caved to the pressures of the far left, and unleashed an unprecedented partisan filibuster. First time in 238 years of this institution. I was honored to be at the White House, East Wing, on January 31st with President Trump when he made the announcement that Judge Neil Gorsuch would be the nominee to replace Antonin Scalia. Judge Gorsuch's academic accomplishments are nothing short of being absolutely stellar. His decision to serve as a justice in the highest court of the land is a true testament to his character, his intelligence, his understanding of the law, and his commitment to the Constitution. Judge Gorsuch was appointed by President George W. Bush to the 10th Circuit in 2006. He was unanimously confirmed by the United States Senate. In fact, some of those Democrats who did not oppose Judge Gorsuch then included his Harvard Law classmate, Barack Obama, Vice President Joe Biden, and Minority Leader Chuck Schumer. Of utmost importance in a justice is a desire and the ability to apply the law as it was intended, not to legislate from the bench. So I can tell you, I was very thrilled to hear Judge Gorsuch say this. He said, "A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the law demands." On February 9th, I met Judge Gorsuch in my office. Let me tell you, he's impressive. We discussed the Constitution. We discussed the Second Amendment. I represent the state of Montana. I can tell you, as we look at our Constitution and our Bill of Rights, the Second Amendment is very important to the people of Montana. He will defend the Second Amendment. We talked about the separation of powers, the role of government and federalism, and the Fourth Amendment. And through 4 full days of hearings, Judge Gorsuch eloquently answered Judiciary Committee members' questions, and certainly before the entire viewing audience, the American people, he showcased his brilliant legal mind. Prior to his hearing, he met with 80 senators. He provided the Judiciary Committee 70 pages of written answers regarding his personal record, 75,000 pages of documents including speeches, case briefs, opinions, and written works going as far back as his college days. The White House archives produced over 180,000 pages of email and paper records related to Judge Gorsuch's time at the Department of Justice. During the committee hearing, Judge Gorsuch sat for 3 rounds of questioning, totaling nearly 20 hours. In fact, when Judge Gorsuch appeared before the Judiciary Committee in the United States Senate, it was the longest hearing of any nominee in this century. He answered nearly 1,200 questions during that hearing. By the way, that's nearly twice as many questions as Justices Sotomayor, Kagan, or Ginsburg received. Today's vote was nothing more than a campaign fundraising effort for Senate Democrats. In fact, the Democratic members who have pledged to support him already have threats from liberals of voting them out of office. It's a sad day that this body has become so partisan that for the first time in this body's history, we had a partisan filibuster to more than qualified nominee. Judge John Kane, a judge appointed by Democrat Jimmy Carter, he said in an op-ed for an online legal website, and I quote, "As the saying goes, we could do worse. I'm not sure we could expect better or that better presently exists." There's just no arguing that Judge Gorsuch is a mainstream nominee. Or take Obama's Solicitor General, Neil Gorsuch. Quote, Judge Gorsuch is one of the most thoughtful and brilliant judges to have served our nation over the last century. As a judge, he's always put aside his personal views to serve the rule of law. To boot, as those of us who have worked with him can attest, he's a wonderfully decent and humane person. I strongly support his nomination to the Supreme Court. I remind you, that was President Obama's Solicitor General's words. A nominee of this caliber, who has undergone, as I just mentioned, rigorous vetting, deserves the respect of the members of this chamber. Yet Senate Democrats walked down the road that their former leader did in 2013 by changing the precedent of this body and allowing the U.S. Senate to become even more partisan. The American people want Judge Gorsuch. The polls show that. In fact, they demanded 9 justices on the court. And today we are one step closer to confirming him. Judge Gorsuch is the right replacement to honor the legacy of Justice Antonin Scalia. He has widespread support across the state of Montana. Our ag groups, the NRA, leaders from across our state, 4 Indian tribes in Montana have endorsed Judge Gorsuch. The American people deserve a Supreme Court justice who will uphold the rule of law and follow the Constitution. The American people deserve a Supreme Court justice who doesn't legislate from the bench. The American people deserve Judge Gorsuch to serve them on the United States Supreme Court. And as the American people watched Judge Gorsuch before the Judiciary Committee, they saw an exceptionally qualified nominee for the highest court in the land, someone who was bright, Columbia undergrad, Harvard Law School, Oxford PhD. I would submit that Judge Gorsuch's intellectual capacities are only exceeded by the size of his heart. This is a kind man. This is a brilliant man. This is an independent jurist. And I very much look forward to casting my vote tomorrow to confirm Judge Gorsuch.
Mr. President.
Senator from South Dakota.
Mr. President, today we are one step closer to a vote to confirm Judge Gorsuch to the Supreme Court. When he is voted on tomorrow, and I look forward to that vote, we will be confirming a justice to the Supreme Court who is supremely qualified, who is a mainstream judge, who respects the rule of law and the Constitution, and who will rule impartially from the bench, someone who will call balls and strikes. That is what I believe the American people look for when they look for a Supreme Court justice. And it was always clear that some Democrats would oppose any Supreme Court candidate the president nominated, but I had hoped that partisanship would be at least somewhat limited. I'd hoped that Democrats would want to preserve the Senate's nearly 230-year tradition of confirming Supreme Court justices by a simple majority vote. And I'd hope that more than a handful of Democrats would join us to confirm one of the most, as I said, supremely qualified judges in my memory. But, Mr. President, that's not what happened. Despite Judge Gorsuch's qualifications, despite the support for his nomination from both liberals and conservatives, the vast majority of Senate Democrats were determined to block this confirmation. Of course, Mr. President, it wasn't really ever about Judge Gorsuch. It's not that Democrats were determined to block his confirmation. It's that they were determined to block any confirmation. Democrats tried to offer reasons to oppose Judge Gorsuch, but they struggled to come up with anything plausible. The Senate Minority Leader actually came down to the floor and tried to argue that he was worried that Judge Gorsuch would not be, and I quote,
a mainstream justice? Well, Mr. President, over the course of 2,700 cases on the 10th Circuit, Judge Gorsuch has been in the majority 99% of the time. 99%. In 97% of those 2,700 cases, the opinions were unanimous. So I'd love to hear, Mr. President, an explanation for how exactly a judge who's been in the majority 99% of the time is out of the judicial mainstream. Was the minority leader attempting to argue that all of the judges on the 10th Circuit, including those appointed by Democrat presidents, are out of the mainstream? Well, Mr. President, the fact is Democrat opposition to Judge Gorsuch had nothing to do with his qualifications. I doubt that any of my colleagues on the other side of the aisle really think that Judge Gorsuch is out of the mainstream or that he lacks the qualifications of a Supreme Court justice. But they opposed him anyway. And Mr. President, if they opposed a judge with a distinguished resume and a reputation as a brilliant jurist, if they opposed a judge who is known for his fairness and impartiality, if they opposed a judge whose nomination has been repeatedly supported by liberals as well as conservatives, if they opposed a judge who unanimously received the highest possible rating from the American Bar Association, a rating, I might add, that the minority leader once called the gold standard for judicial nominees, if they opposed a judge a number of them supported 10 years ago, then it's abundantly clear that their opposition wasn't about this judge, but about any judge that this president nominates. And thus, Mr. President, Republicans were left with no real alternative but to act to preserve the Senate's tradition of giving Supreme Court nominees an up or down vote. This wasn't my preference. I'd have preferred to leave room for a minority to block a judge who was truly not fit for office, but it's the only alternative we were left with if we wanted to confirm anyone to the Supreme Court. Historically, Mr. President, confirming judges was not a partisan process. During the George W. Bush administration, however, Democrats decided that they were going to change that. They were mad back then, too, mad that a Republican president was in charge. Apparently, modern-day Democrats are not reconciled to the fact that in our system of government, it's not always the Democrats who win. Anyway, Mr. President, Democrats were mad, and they decided that the historically bipartisan process of confirming judicial nominees was going to change. Their 2003 filibuster of Miguel Estrada, who had been nominated to a seat on the Court of Appeals for the D.C. Circuit, was the first time a judicial nominee who enjoyed clear majority support was not confirmed because of a filibuster. Democrats ultimately successfully filibustered no fewer than 10 Bush nominees to appellate courts. That was a massive reversal in Senate history. Suddenly, the normally smooth process of confirming a president's judicial nominees had been turned into an exercise in partisanship. 10 years later, Democrats struck again when they employed the nuclear option to ensure that they could pack the D.C. Circuit, despite the fact that at the time when the current minority leader announced that Democrats would, and I quote, fill up the D.C. Circuit one way or the other, end quote, Republicans had blocked just 2 of President Obama's circuit nominees and had confirmed 99% of his judges. 215 out of 217 under President Obama up to that point. And now here we are today. Democrats are again mad that they lost an election, that they can't control the nomination process, and they once again turned to no-holds-barred partisanship. And they made it clear that no Republican nominee would ever make it to the Supreme Court. And thus we had to act to ensure that Supreme Court nominees can receive an up or down vote going forward. Mr. President, the Senate's nearly 230 years. The filibuster has been used to block a Supreme Court nominee exactly once. One time. Supreme Court Justice Abe Fortas's nomination to be Chief Justice of the Supreme Court was blocked by a bipartisan coalition, in part over ethical concerns. That's how strong the Senate's bipartisan tradition of an up and down vote on Supreme Court nominees has been. 230 years, one time, and it was bipartisan. Mr. President, I'm deeply sorry that the Democrats were determined to end that tradition. Judge Gorsuch should never have faced the threat of a filibuster. There was no reason other than the most flagrant partisan politics to block this supremely qualified nominee for the Supreme Court. Mr. President, as I said, I look forward tomorrow to this final vote where we have an opportunity to confirm to the Supreme Court this well-qualified mainstream nominee who fundamentally respects the rule of law and the Constitution of the United States and will act impartially as a justice for the American people. Mr. President, I yield the floor. Mr. President, I suggest the absence of a clerk will call the roll.
Mr. Alexander.
Mr. President.
Senator from Alabama.
Are we in a quorum call?
We are.
I ask unanimous consent that the quorum call be dispensed with.
Without objection.
Mr. President, I'd like to address the Senate for a few minutes about the nomination of Judge Neil Gorsuch, which is the topic of the day, and it's been the topic for weeks up here. It's probably been said, but I'm going to go through some of it again. Judge Gorsuch is a native of Denver, Colorado, where he currently resides with his wife, Louise, and their 2 daughters. He's currently 49 years old. But I want to talk to you about some of his credentials. Judge Gorsuch received his Bachelor of Arts degree from Columbia University in 1988, his Juris Doctor from Harvard Law School in 1991, and a doctorate in legal philosophy from Oxford University in the UK in 2004. At Columbia, he was a member of Phi Beta Kappa, a Truman Scholar at Harvard Law School, and, Mr. President, a Marshall Scholar at Oxford. Following law school, Judge Gorsuch served as a law clerk to Federal Appellate Judge David Sentell, and then to Justice Byron White of the U.S. Supreme Court and Associate Justice Anthony M. Kennedy of the Supreme Court. In 1995, Mr. President, Judge Gorsuch entered private practice as an associate of Kellogg, Huber, Hanson, Todd, Evan, and Fiegel, and he was elected a partner in that law firm in 1998. His practice focused on general litigation in both trial and appellate matters. Judge Gorsuch left private practice in 2005 to serve as the principal deputy to the Associate Attorney General at the Justice Department here in Washington. President George W. Bush nominated Judge Gorsuch to the 10th Circuit Court of Appeals located in Denver on May the 10th, 2006. He was confirmed right here in the Senate by a voice vote, Mr. President, on July the 20th, 2006. We talk about qualifications for judges. I want to share some of his. Judge Gorsuch has served for over a decade on the U.S. Court of Appeals for the 10th Circuit. He has an outstanding judicial record that speaks for itself. He's participated in over 2,700, Mr. President, 2,700 appeals on the 10th Circuit, and 97% of them have been unanimously decided. He was in the majority in those cases 99% of the time. Of the approximately 800 opinions that he authored on the 10th Circuit, 98% of his opinions were unanimous, even on a circuit where 7 out of the 12 active judges were appointed by Democratic presidents. His opinions on the 10th Circuit have the lowest rate of dissenting judges at 1.5%, unheard of. Out of the 8 cases that he's decided that were reviewed by the U.S. Supreme Court, 7 were affirmed and 1 was vacated. Judge Gorsuch's nomination to the 10th Circuit Court of Appeals in 2006 was met with opposition as he was confirmed, met without opposition basically, and he was confirmed, as I said, by voice vote. Notably back then, senators serving during this time, including a lot of my former colleagues, then Senator Barack Obama, Senator Joe Biden, Senator Hillary Clinton, Senator John Kerry, Senator Harry Reid, and 12 other current sitting Democratic senators in this body, including the minority leader, Chuck Schumer. In March, the American Bar Association, ABA, unanimously gave Judge Gorsuch a well-qualified rating, their highest possible mark. Minority Leader Schumer and Senator Leahy have both previously referred to the ABA as the gold standard by which judicial candidates are judged. In the area of jurisprudence, Mr. President, Judge Gorsuch has a mainstream judicial philosophy, which he clearly articulated during the Senate Judiciary's confirmation here. His record, I believe, is unequivocal in that he believes judicial decisions should be based on the law and the Constitution and not personal policy preferences. He has a deep commitment to the Constitution and its protections that established by our founding fathers, including the separation of powers, federalism, and the Bill of Rights. Judge Gorsuch's decisions demonstrate, I believe, that he consistently applies the law as it is written, fairly and equally to all individuals. Additional information about Judge Gorsuch. The American people, I believe, deserve to have their voices heard in selecting Justice Scalia's replacement. This is what we're doing. Some of my colleagues intend to oppose Judge Gorsuch, based solely on the fact that they disagree with the outcome of the presidential election. During President Trump's campaign last year, he clearly defined the type of justice he wished to nominate to the current vacancy, and even published, as you'll recall, Mr. President, a list of 21 judges who possessed what he believed are the necessary qualifications to serve on the U.S. Supreme Court. Following Judge Gorsuch's nomination, he sat for over 20 hours of questioning in front of the Senate Judiciary Committee here in the Senate, the longest hearing of any 21st century nominee. Additionally, he was given 299 questions for the record by my colleagues on the other side of the aisle. This also is the most in recent Supreme Court confirmation history. Mr. President, simply put, I believe this is the most open and transparent process in choosing a Supreme Court nominee ever conducted by an administration. By filibustering this nomination, some of my colleagues are breaking a nearly 230-year tradition of approving Supreme Court nominees by a simple majority vote. I believe the American people spoke clearly when they elected President Trump. This, I believe, is the American people's seat, and I believe, Mr. President, that Judge Gorsuch is an exceptional choice for the Supreme Court. He deserves an up and down vote, and that's why I believe we're getting ready in the next few hours to confirm him. I yield the floor, suggest the absence of quorum.
The clerk will call the roll.
Mr. Alexander.
Senator from Connecticut.
Thank you, Mr. President. I ask that the quorum call be lifted.
Without objection.
Thank you, Mr. President. Mr. President, as we finished the vote just hours ago, I could not help but notice a number of my colleagues on the other side of the aisle high-fiving each other. That image stays with me as I stand here now. It saddens me. There is no cause for celebration in what happened in the Senate just hours ago. No one should sleep well tonight. No one should underestimate the magnitude of what happened here. Damage was done to our democracy, to, in fact, two institutions that are the pillars of our democracy, the United States Supreme Court and the Senate itself. Today is indeed one of my saddest in the Senate. Sadder than anything is the damage that has been caused to the Supreme Court by eroding and undermining trust and respect for an institution that has power only because of its credibility with the American people. It has no armies or police force. All it really has is the confidence and respect of the American people. And today, raw political power has been exercised to break the rules and norms of this body so that a nominee could be confirmed. And the only way that he could be confirmed was, in fact, to wreck the rules. A nuclear option that will have enduring fallout and rippling repercussions, perhaps in years to come. For myself, I would state unequivocally that I hope we will work together on issues where we have common ground, where we can reach common solution, on infrastructure, on tax reform, on immigration issues. But no one should make light of the potential fallout, as there is in any nuclear explosion from this action today. The Senate has broken with decades of bipartisan practice when it comes to the United States Supreme Court. The practice and tradition was that presidents of either party would consult with members of both parties in this body before making a nomination, so as to assure a mainstream nominee. And that nominee would be in the mainstream even before his or her selection, so that there was some modicum of comedy, and so that respect for this body as well as the courts would be preserved. My fear is that the contagion of partisanship will infect the court system as a whole, all of the nominations to lower courts, as well as the appellate courts, will be affected. My hope is that we can avoid that truly cataclysmic outcome. A nuclear explosion, in some ways even more deafening and damaging than would be the one used today. Because our courts are the bulwark of our democracy. An attack on the courts is an attack on the only check that we have against tyranny and autocratic erosion of those rights. And that is why the nonpartisanship of our courts is so important The Supreme Court of all our courts should be above politics. And in fact, that is why the 60-vote rule for the Supreme Court was so important. The Supreme Court is different. 9 justices appointed for life to the highest court in the land, in some ways an anachronism in our democracy. Unaccountable, unelected, sitting for life, with the power to strike down actions of elected representatives and an elected executive by issuing words on paper without the direct means to enforce them, depending only on respect and credibility from the American people. To approve nominees by a razor-thin majority is a disservice to the court and to our democracy. Supreme Court justices do more than just follow the law. They have to resolve conflicts in the law and differences among the lower courts where they disagree, and in fact, ambiguities in the statute where there is lack of clarity, where this body is unable to reach consensus and, in effect, decides to agree to the extent it can and leave some questions to administrative agencies, which rightly are entitled to respect as they implement the law. Confidence and trust are essential, and we have undermined it today. Our Republican colleagues have gravely damaged it by the action taken today. Now, I have urged my colleagues to reject Neil Gorsuch because I believe he is out of the mainstream, because he failed to answer questions about whether he agreed with established core precedents essential to rights of privacy and equality under the law, because he has a judicial philosophy that would involve substituting the judgments of courts for administrative agency and abandoning the Chevron doctrine, and because he favored in many of his actions, opinions, writings, the interests of corporations over individual rights. We have debated the merits of this nominee, and I believe that the evasion of questions that I put to him repeatedly, and others as well, leaves us with the inescapable conclusion that he passed the Trump test, that he is not a neutral caller of balls and strikes, that he is, in fact, an acolyte of the right-wing groups that screened and suggested his name, and that he would carry out not only the Trump litmus test to overrule Roe v. Wade and strike down gun violence provisions, but also other unknown decisions that would implement that far-right conservative agenda. We can debate whether that view is right or wrong. But today's sadness for myself, and it is one of my saddest in the Senate, goes more to the institution that has been demeaned and degraded, the United States Senate and the Supreme Court. My hope is that maybe it will be a turning point. Maybe we can reconstruct the sense of bipartisanship and comedy that existed for so many years. Many of my colleagues on the other side have expressed to me their misgivings about what was done today. But the obstruction of Merrick Garland's nomination, as one of my colleagues put it, the filibuster of all filibusters, was another step in a continuing progression culminating in today's action that very much betrays the spirit and values of bipartisan selection of Supreme Court nominees, because the highest court in the land is different. I had the extraordinary honor to clerk for a justice of the United States Supreme Court, Harry Blackmun, who was appointed by a Republican president, Richard Nixon. He grew as a justice and surprised a lot of people. He no doubt surprised the president who appointed him. And that is what happens to really extraordinary men and women who serve on our courts as well as in the United States Senate. They grow in the job. And choosing a United States Supreme Court justice is one of the most solemn and important duties that a president has, and confirming her or him is one of the most important tasks we have in this body. Even at the most difficult and contentious times, as I served then as a law clerk and as I have litigated since then for several decades, I have never doubted that judges were working in good faith to uphold the rule of law. Whether they ruled my way or not, I believe that they were working to try to be above partisan politics and uphold the rule of law and do the right thing to follow the law. But the Supreme Court does more than follow, it leads. Today's vote is a significant challenge to that principle, and perhaps the most difficult that we have seen in recent history. It threatens to exact profound damage on the confidence and trust the American people have in the Supreme Court and perhaps in the courts overall, and that is a danger for all of us. In my view, when the history of this time is written, there will be two heroes: the free press, who have uncovered abuses and wrongdoing despite opposition from many powerful forces, and our independent judiciary that has upheld their right to do it, and also the rights of countless Americans in many, many areas of law. Today's action threatens those two forces for good, two institutions in our society. It undermines our rules. It would not have happened without a choice made by the Republican leadership, that they were willing to break the rules to achieve this result. I am determined to try to move forward in a positive way, in legislation, as well as in protecting and enhancing our courts, giving them the resources they need to do their job, and law enforcement the resources it needs to uphold the rule of law. We cannot hold the Supreme Court hostage to any ideology. And that is a lesson from today and from the past year that we should all heed. Mr. President, I will continue to talk about this topic because I believe it is so profoundly important to our nation. But for now, I yield the floor, and thank you.
When they write the history of these times, I'm sure when it comes to Senate history, this is going to be a chapter, a monumental event in the history of the Senate, not for the better, but for the worse. And after we're all long dead and gone, somebody may be looking back and trying to figure out what happened and what motivated people. I'm going to tell you what's motivated me since I've been in the Senate. An understanding that the job of a senator when it comes to advising consent is not to replace my judgment for that of the president, not to nullify the election, but to be a check and balance to make sure that the president of either party nominates someone who's qualified for the job and is capable from a character point of view of being a judge of us all and has the intellect, background, judgment, experience carry out the duties of the Supreme Court justice. I expect that when President Obama won the White House, that he would pick judges that I would not have chosen based on our different philosophies of liberal conservative jurisprudence. So this is what Greg Craig, the former White House counsel in the Obama administration, said about Elena Kagan, who is now on the court. Kagan is a progressive in the mold of Obama himself. This is what Vice President Biden's Chief of Staff, Ronald Klein, said about Elena Kagan. Elena Kagan is clearly a legal progressive and comes from the progressive side of the spectrum. I think that was an accurate description of her and Sonia Sotomayor. They both are progressive judges that come from the progressive side of the judicial spectrum. Both highly qualified, capable women who had a stellar legal record, even though they had outcomes I did not agree with. They were certainly in the mainstream. Both had been judges, and I think he chose people that I would not have chosen, but were really highly qualified. I was the only member of the Judiciary Committee on the Republican side to vote for either one of the Ms. Kagan or Ms. Sotomayor, because I used a standard that I thought was constitutionally sound. I'm not telling any other senator what they should do. I'm just trying to explain what I did. The Federalist Papers number 76, written April the 1st, 1788, by Mr. Hamilton, said, "To what purpose then require the cooperation of the Senate? It would be an excellent check upon a spirit of favoritism in the president. It would tend greatly to prevent the appointment of unfit characters from state prejudice, from family connection, from personal attachment, and from a view to popularity." So from Hamilton's point of view, it was a check and balance against a crony or an unqualified person, someone who was popular but not qualified for the job. Somebody was appointed because they were close to the president, not qualified for the job. Somebody that was appointed because they were a favorite son of a particular state, that would not be fair to everybody else. When you look at the history of the advising consent clause, it's pretty clear that I don't think the Founding Fathers had in their mind that one party would nullify the election when a president of another party was chosen by the people when it came to Supreme Court confirmation, because they chose somebody they did not agree with philosophically. So I voted for Elena Kagan and Sonia Sotomayor, knowing that they come from the progressive judicial pool. And Neil Gorsuch is one of the finest conservatives that any Republican president could have chosen. And he is as every bit as qualified as they were. His record is incredible. 10 and a half years on the bench, 2,700 cases and one reversal. He received the highest rating of the American Bar Association of well qualified, just like Sonia Sotomayor and Elena Kagan. To merit the committee's rating of well qualified, a Supreme Court nominee must be a preeminent member of the legal profession, have outstanding legal ability and exceptional breadth of experience, meet the very highest standards of integrity, professional competence, and judicial temperament. The rating of well qualified is reserved for those found to merit the committee's strongest affirmative endorsement. By unanimous vote on March 9th, the Standing Committee awarded Judge Gorsuch its highest rating of well qualified, just like they did for Sonia Sotomayor and Elena Kagan. 2,700 court decisions, one reversal, praise from all areas of the law, left, right, and middle. The ABA report of 900 pages describes a very thoughtful man, an incredible judge, a good person. So I don't think anybody can come to the floor and say, even though you may disagree with an outcome, that Judge Gorsuch is not qualified using any reasonable standard to be chosen by President Trump. He's every bit as qualified as the two Obama appointments. So clearly qualifications no longer matter like they used to. Anthony Scalia, who Judge Gorsuch, hopefully will soon be Justice Gorsuch, was confirmed by the Senate 98-0. Ginsburg, Ruth Bader Ginsburg, 96-3. I would argue that you could not find two more polar opposite people when it comes to philosophy than Justice Ginsburg and Justice Scalia, and they became very dear friends. But nobody in their right mind would say there's not a difference in their judicial philosophy. Strom Thurmond, my predecessor, very conservative man from South Carolina, voted for Miss Ginsburg. Clearly, a conservative would not have chosen her because she was the general counsel with the ACLU. And I can tell you that Ted Kennedy and other people on the progressive side of the aisle would not have voted for Anthony Scalia based on philosophy. Something's happened in America from 1986 and 1993. The Constitution hasn't changed. Something has changed. And I think the politics of the moment have taken the Founding Fathers' concept, turned it upside down, that from the time that Scalia was put on the court and Ginsburg was put on the court, everything has changed. So I was here when the first effort to filibuster judicial nominations was made in earnest. The first term of Bush 43, there was a wholesale filibustering of circuit court nominees of President Bush. I was part of the gang of 14 that broke the filibuster. We lost a couple of nominees, but we did move forward. And we said there would be no further filibuster of judges unless there was an extraordinary circumstance. That allowed Alito and Roberts to go forward. Both of them got a good vote. Alito, we had to get cloture, but we got 78 votes. Clarence Thomas was probably the most controversial pick in my lifetime. And if you can remember that hearing, it was just, news, front page news every day and on TV every night. Not one Democratic senator chose to filibuster him. He got an up or down vote, and he passed, I think, 52-48. And they could have chosen to require cloture, but they didn't. So this is the first time in the history of the Senate that you've got a successful partisan filibuster of a Supreme Court nominee. Abe Fortas was filibustered to be Chief Justice of the Supreme Court by almost an equal number of Democrats and Republicans because of ethical problems, and he eventually resigned. So we're making history today. The first successful filibuster in the history of the United States Senate to deny an up or down vote on a nominee to the Supreme Court. And it breaks my heart that we're here. I don't know what to do other than change the rules to have some sense of fairness. I can't believe that Judge Gorsuch is not qualified by any reasonable standard. I voted for Sotomayor and Kagan. Nobody even asked for a cloture vote. They went straight to the floor. One got 62 votes, 63 votes. The other got 68 votes. And I don't know why we can't do for Judge Gorsuch what was done for Sotomayor and Kagan. We keep hearing about Judge Garland. Judge Garland's a fine man, would have been a very good Supreme Court justice. Justice Scalia died in February of 2016 after 3 primaries were already held. The nominating process was well on its way for picking the next president. So this was an election year. And I remember what Joe Biden said in '92, the last year of Bush 41's term, when there was a suggestion that somebody might retire in the election year. And he said, basically, if someone steps down, I'd highly recommend the president not name someone, not send a name up. If he, Bush, did send someone up, I would ask the Senate to seriously consider not having a hearing on that nominee. It would be our pragmatic conclusion that once the political season is underway, and it is, action on a Supreme Court nomination must be put off until after the election campaign is over. That's what Vice President Biden said when he was chairman of the Senate Judiciary Committee in '92. That made sense. President Trump put a list of names out that he would choose from if he became president, which was historic. Part of the contest in 2016 was about the Supreme Court. I have no problem at all saying that once the campaign season's afoot, that we'll let the next president pick, and that's no slam on Judge Garland, fine man. I got zero doubt if the shoe had been on the other foot, there'd have been a different outcome. I can't imagine Harry Reid being in charge of the Senate in 2008 and would allow President Bush in his last year to nominate somebody to the court, and they would approve that decision once the campaign season had started in 2008. I say that knowing that it was Senator Reid who chose to change the rules in 2013, which broke the Gang of 14's agreement in part. And here's what Harry Reid said in 2005. The duties of the United States Senate are set forth in the Constitution of the United States. Nowhere in that document does it say the Senate has a duty to give presidential nominee a vote. All I can say is that in the 100-year history of the Senate, from day going backwards, there's been one person put on the court when the president was of one party and the Senate was held by the other party, and a vacancy occurred in the last year of a presidential term. We've done nothing that would justify Judge Gorsuch to be treated the way he's been treated. And he's been treated pretty badly. Here's what Nancy Pelosi said. If you breathe air, drink water, eat food, take medicine, or any other way interact with the courts, this is a very bad decision. All I can say is that Judge Gorsuch does not deserve that. That is a political statement out of sync with the reality of who this man is and the life he led. And it's that kind of attitude that's gotten us here today. I can also say there's blame on my side too. Nobody has clean hands completely on this. I can remember when Justice Sotomayor was nominated, she made a speech to the effect that a white man would have a hard time understanding what life is like for minorities. And that was taken to believe that she somehow could not be fair to white men. That was a speech she gave, provocative, but I never believed it was an indication that she somehow was prejudiced against white men. And the reason I concluded that was that everybody who had known her, including white men, said she was a wonderful lady. I remember Elena Kagan, the attack on our side was that she joined with the administration of Harvard to kick the ROTC unit off campus. Somehow that made her unpatriotic. Well, my view was that that was the position of a very liberal school called Harvard, and no one could ever convince me that Elena Kagan was unpatriotic. She seemed to be a very nice, highly qualified lady, and that decision by Harvard could not be taken to the extreme of saying that she's not fit to serve on the court. So I was able to look beyond the charges leveled at these two ladies on our side to understand who they really were. And when you look at people who know these judges the best, they can tell you the most accurate information. In the case of Kagan and Sotomayor, there were a lot of people left and right who said they were well qualified, fine ladies. And when you look at what was said about Judge Gorsuch in the ABA report, just an incredible life, well lived. So here we are. We're about to change the rules. Up until 1948, it was a simple majority requirement for the Supreme Court. As a matter of fact, most Supreme Court nominations in the history of the country, a large percentage were done based on a voice vote. It's only modern times where we've gotten this political contest over the court. Probably started with Judge Bork. Some blame to go around on both sides, but I can say this, that while I've been here, I've tried to be fair, the best that I know how to be. I voted for everybody I thought was qualified. I said, as to Judge Garland, let the next president decide. And at the time I said that in March of 2016, I had no doubt in my mind that Donald Trump would lose, that Hillary Clinton would pick somebody probably more liberal than Garland. But it made sense to me in that stage in the process to let the next president pick. So the fact that we're filibustering this man says a lot about the political moment. If this were a controversial character, I might could understand it better. So when you look back and try to figure out what we did and how we got here, I can say this, that we took one of the best people that President Trump could have nominated, somebody I would have chosen if I'd gotten to be president. I think Paul Ryan, Mike Pence, any of us would have chosen Neil Gorsuch. And he was denied an up or down vote. And that says all we need to know about the political moment. It will change the rules. It will have an effect on the judiciary, and it won't be a good one. Because in the future, judges will be selected by a single party if you have a majority. No requirement to reach across the aisle, which means the judges will be more ideological. When you have to go over there and get a few votes, or when they have to come over here and get a few votes, you're going to water down a little bit some of your choices, and the most extreme ideological picks available to a party or president are probably not going to be able to make it through. Now they will. So I think what you'll see over time is that the most ideological people in the Senate are going to have a lot to say about who's chosen by the president. So it will change the nature of the judiciary. Into the Senate itself, every Senate seat now becomes a referendum on the Supreme Court. So when we have a contest for a Senate seat, it's not just about the Senate, it's about the seat affecting the outcome of the court, because all you need is a simple majority. Whether or not it leads to changing the legislative filibuster, which would be the end of the Senate, I don't know, but I don't think it helps. There'll be a majority around here one day, a president of the same party, control of the House, and they'll get frustrated because the other side won't let them do everything they want to do. And they'll be tempted to go down this road of doing away with the 60-vote requirement to pass a bill, not appoint a judge. And that'll be the end of the Senate. We've made that more likely by doing this. It was more likely in 2013. I hope I'm wrong, but I think we set in motion the eventual demise of the Senate. But the one thing I can say on an optimistic note, that while I'll vote to change the rules for this judicial nomination, I will not ever vote to change the rules for legislation. And the reason I'm voting to change the rules is I don't know what I go home and tell people why Sotomayor and Kagan got on the court and Gorsuch couldn't. Why President Obama was able to pick 2 people that were highly qualified, and Trump wasn't able to pick 1 person highly qualified. You just can't have it where one side gets their judges and the other side doesn't. So to rectify that wrong, I guess we'll have to change the rules. Not a good day. Hoping it would never come, but it has. And to the extent that I've been part of the problem, I apologize to the future. But I think I've, at least in my own mind, tried to do the right thing as I saw it. I took a lot of heat for voting for their judges at a time there was a lot of hate on our side. I'm glad I did. Not that I'm not partisan, I certainly can be, but I just think the history is going down a very dark path. The Senate's going down a very dark path here, and there'll never be another 98 votes for a Scalia, 96 votes for a Ginsburg, and that's a shame, because even though they may be different, they have one thing in common. They're good people who are highly qualified to sit on the court. And I can understand why a liberal president would choose one and a conservative president would choose another. What we're doing today is basically saying we don't really care about election results anymore in the Senate. With that, I yield.
Senator from Louisiana.
Thank you, Mr. Acting President. Senator Graham, my fellow senators, our constituents in the gallery. A lot of what's going on today, Mr. President, may seem very complicated. We've heard a lot of terms being thrown around, cloture, the nuclear option. But really, the question that we were faced with today in the United States Senate was very simple, and it continues to be pretty simple and straightforward in my judgment. Should we have an up or down vote on the nomination of Judge Neil Gorsuch to be an Associate Justice of the United States Supreme Court? And the Senate earlier today, Mr. President, voted to do that. And I think it's very important for the American judicial system and for the American system of democracy that the United States Senate be allowed to vote on Judge Gorsuch's nomination to the United States Supreme Court. It wasn't enough to only vote on a motion to end debate. We also needed to be allowed to vote on the actual nomination. Yes or no. Now, unfortunately, our friends on the Democratic side of the aisle decided to filibuster in order to make it impossible for us to vote on this crucial nominee without modifying the rules of the United States Senate. And that's what we did earlier today. I don't know that anybody did it happily, but certainly a majority of the United States Senate believed that the American people deserved an up or down vote, yay or nay, stand up and be counted in front of God and country. Do you want Judge Neil Gorsuch to be on the Supreme Court, or do you not? And that vote is going to take place tomorrow afternoon. Now, the Constitution, Mr. President, says that the President of the United States, and I'm quoting now, shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court, end quote. And I don't need to tell you, Mr. President, that this is an extremely important part of our separation of powers. It's vital to protecting the integrity of the Supreme Court. The work that all of us do, not just members of the Judiciary Committee, but every member of the Senate does in vetting our nominees and making sure they're qualified and independent, as is Neil Gorsuch, is enormously important for the protection of liberty itself. And let's not ever forget, Mr. President, what we are protecting. We are protecting justice, and we are protecting liberty. We're not supposed to be protecting a certain point of view. We're not supposed to be protecting a certain policy preference. We're not supposed to be protecting a certain political party. And I hope that tomorrow, when we finally get the opportunity to vote up or down on Neil Gorsuch for membership on the greatest tribunal in the history of civilization, in my judgment, the United States Supreme Court, that we will consider his nomination in light of how it will affect our country, not our party. When we look at his nomination from that perspective, Mr. President, and leave the politics of the last few years in the rearview mirror, I think we can analyze his nomination with a lot more clarity. You know, Alexander Hamilton, who I think most Americans admire, said in Federalist number 78, he said that the court has, quote, neither force nor will, but merely judgment. Merely judgment. And I think that's what we're all looking for, or should be, in a nominee to any court, but especially the United States Supreme Court. We're not looking for somebody with a certain policy preference. We're not looking for people with ideas of how the law can be improved, because the role of a judge is not to make law. It's to interpret the law as made by the legislative body as best that judge can understand it. And that's why, Mr. President, we need someone like Neil Gorsuch, in my estimation, with good judgment. Neil Gorsuch, I sit on Judiciary, Mr. President. I spent 20 to 40 hours with him or with people who know him well, hearing their testimony. I've read his opinions. As far as I'm concerned, he's as good as it gets. I can't imagine that President Trump could have picked better. He's a thoroughbred. He's a legal rock star. If you read his opinions, you'll see he's painstaking in his application of the law to the facts before him. He writes beautifully. His communication skills are absolutely amazing. His analysis and analytical rigor is clear. It's concise. His decisions are wise. They're disciplined. And he's faithful to the law. He's an intellectual, Mr. President. He's not an ideologue. He's a judge, not a politician. He's a whip-smart, clear-writing, strict constitutionalist, snow skiing, fly fishing, fourth-generation Coloradan. And I think he'll serve every person in our country well as a member of the Supreme Court, and that's why I'm supporting him. And let me say one final thing, Mr. President. I don't think there is any vote that will be more important than the vote that we will take tomorrow on a president's nomination to the United States Supreme Court. So I want to choose my words carefully here. Not a single solitary vote is more important than that vote we'll take tomorrow. But that's not to say, Mr. President, that there aren't other important issues before this body. And that's why I think it was so important today that we decide to vote up or down on Judge Gorsuch so we can move on to those other important issues. The fact of the matter is, and the issues I'm talking about, Mr. President, are jobs, designing a healthcare delivery system that looks like somebody designed it on purpose, which our acting president has worked so hard on, infrastructure, elementary and secondary education, a skilled workforce, and I could go on. Because there's an enormous amount of pain.